So last occasion, your lordship directed my learned senior friend to take instruction that why this amount has been deducted in spite of the fact there is a direction that the payment should be made on the basis of the entitlement that taken at risk.
Lordship, here, Lordship, kindly see the page 11, Lordship. Once a compliance exceptional, Lordship. It is chairman, Niki.
Chairman, Birhun district.
But
Page 11.
page 11, Lordship. 1-1. Exceptional, Lordship, on the basis of the letter, Lordship, District Inspector of School and Lordship, Director of Pension and Provident Fund consult about the both, Lordship. Let the matter be adjourned for 1 week. In the meantime, I think, Lordship, problem has been solved. Or whatever.
Oh. This also makes his case much more stronger.
But first, Lordship, here, Lordship, Lordship adjourned the matter was hard last week, Lordship.
Correct. This also he admits that with effect from 1st July
Lordship, here,
2015,
Lordship,
he is getting a
so, Lordship, he consult about
he
his
has retired on subsequent date.
thereafter, Lordship, he consult about it. Give me 1 week time. In the meantime, Lordship, I think, Lordship. But here,
Mr. Bhaskar Prasad Boisho,
Kindly
advocate for the arrest.
Record submission of my learned senior friend.
yes, but I am not finalized. I am only consult.
Can you record the submission of my learned senior friend?
It is not required, but
Not
page
necessary,
11,
Lordship. I am
page 11 shows that you have been given effect of that from him.
Yes, Lordship.
That is what he was indicating, but there is, if that be so, then he is entitled to get that.
If Lordship, he or she is entitled, Lordship, I am bound to Lordship.
Mr. Bhaskar Prasad Boisho, an advocate representing alleged contemner, seeks 1 week accommodation to take further instruction. Next week. Follow. Wednesday. 5th of.
Lordship, I am only on indulgence, Lordship. Last order, Lordship, I think the server is not upload, Lordship. Last order.
Ashe server?
No, Lordship, I am just now, I am not. Kindly, Lordship. नहीं, I mean,
Check करो. Bullshit नहीं server. Check.
I am getting. I know.
করছে এস লিখেছে কেন দেখো তো আমি তো আসেনি যখন আসবে দেখিয়ে দিবে এস লিখছে কেন উইদাউট সার্ভার হ্যাঁ নেক্সট
Madam for the applicant.
এই সুরিত বাবু
Lordship.
ওটাকে চেক করে নেবেন ফার্স্ট অলটা আপলোড হবে তারপর আপনি করবেন ইয়েস
Madam for the application.
it will be uploaded.
Lord, this is a contempt application, Lordship. Order dated 3rd September 2025, Lordship. Kindly come to page, Lordship. 23, Lordship. Lordship's order.
The notice to issue after 4 weeks issue notice.
Greatly.
Lordship, I'm paying for a short pass over. Direction was issued your lordship to file report your lordship. May report in the form of affidavit. Lordship just we received this report.
Lordship passed over.
But I appear for the petition.
My lord, I appear for the Madrasa Service Commission.
You are right now, you're
Yes,
fine.
I had a viral fever. Now it was so badly it weekends, so I couldn't come for the whole week.
His affidavits have been filed.
No, my lord.
My lord, may I have just 2-3 things for lordship's considerations, because I have read the respect, because there is a large number of matters from item 4 to 15.
15.
I have seen. Now, essentially, my lord, they are now relying on a division bench judgment of 16th of April 26. I'm only requesting your lordships to, this copy might have been given, but if not given, I have a copy. Kindly have a look at, my lord.
But
It must be filed, or lordship may take, this is also here.
the last occasion, my lord, I have handed over, my lord.
বার করে দিও,
Lordship can take this copy, this photocopy is here.
এটা বার করে দিও। Yes,
My lord, I have 2 submissions. One submission which nothing to do with this division bench judgment, that is a factual, that the commission on the point of, may I just give the basic context. The context was the writ petition was dismissed at the very admission stage without any direction for opposition on reply. That was the stage which was challenged before the Honorable Division Bench. Today's situation is that Honorable Division Bench have set aside that order of dismissal and ultimately directed, if I can say, 1, 2, 3, 4. According to my understanding, all these 1, 2, 3, 4 are, it means only one thing, as if it is a fresh writ petition. The division bench observations should not influence the honorable single judge, and it has to be decided on merit. This is the context on factual. Now, there is an ancillary point that the commission, my lord, they have taken step to question this order before the Honorable Supreme Court. Today in the morning, I wanted to know from the from my learned friend, what is the situations there in Delhi. Now, I have been told that within 2 to 3 days, they will be able to get the number, the SLP would be filed. But I do not want any kind of delaying for that purpose, because in the SLP, if anything is decided, it will either way automatically be binding before your lordships or any court. So all I am praying is, I would like to show just 3 things from this the division bench judgment. If lordship kindly take this, the judgment. Kindly take, my lord, the basic premise, page number 2, from 2nd paragraph. That Mr. Soumya Majumdar, learned senior advocate, appearing for the appellant, submits that the learned single judge arrived at an incorrect finding that the appellant had approached the court after expiry of the panel, though the records would reveal that prior to expiry of the panel, such and such. These are factual. Now, lordship may kindly thereafter skip and kindly come to next page, page number 3. My lord, this was the submission on behalf of the appellants. If I can read from the top of it, recommendation of such and such persons for appointment and transfer to the post such and such is no longer res integra and has attained finality upon dismissal of the special leave petitions on such and such, preferred by the commission, challenging the order dated such and such, affirming the order dated such and such, passed in Akmal Hussain. In view thereof, the appellant's claim cannot be negated. So that was their submission, that this is no more res integra. Therefore, it will automatically give the benefit we should also get. That was the submission. And in that light, the Honorable Division Bench also recorded, lordship may kindly come to page number 4. My submission, my lord, 2nd paragraph, Mr. Dhar further submits that the appellant appeared in 6 SLST. The panel pertaining to the said selection process has admittedly expired on 30th June 19, and there is no existing vacancy pertaining to the said selection process. I'm only showing, I'm not saying these are the directions. One side is saying this is no more res integra and therefore give us the benefit. The other side, that is me, I am saying that the panel, it has already expired and there is no vacancy. In that two contradictory submissions, after being recorded, the Honorable Division Bench ultimately, same page at the bottom para, starting from the short point. The short point which arises for considerations in the present appeal is as to whether the learned single judge acted erroneously in dismissing the writ petition, kindly mark this, my lord, at the admission stage on the ground of delay. That exactly I said, that there are different stages. Sometimes your lordships do not even admit it on the very first day, dismiss the writ petitions. Sometimes your lordships do not decide anything finality on the first day, simply passes an order of admissions, opposition reply, and thereafter, regardless of what is the submission, based on the merit, decides it. So the Honorable Division Bench found that the Honorable Single Judge was not right in dismissing it on the very first day. And thereafter, my lord, next paragraph, which is important, a declaration of law is a judicial mechanism where a court's rulings are generally retrospective unless the court explicitly declared them prospective. The issue as urged on behalf of the appellant that in terms of the proviso to Rule 3 of 10 rules, a person having desirable qualification shall, if qualified in written examination, grade preference over the candidates who have qualified in written examinations but do not have desirable qualification, has attained finality, kindly mark thereafter, needs to be decided by the learned single judge on merits. But this is that's the reason I wanted that if it is not read in entirety, and impressions might be given that as if the Honorable Division Bench have also decided something on merit on declaration of law. No. After recording that whether this is a declaration of law, then the Honorable Division has clearly, kindly if I can read once more, whether has attained finality needs to be decided by the learned single judge on merits. Thereafter, next paragraph, in view thereof, the impugned order is set aside and this court remands the writ petition to the learned single judge for hearing on merits upon exchange of affidavits, thereafter, without being influenced by the observations made in this order. So this was precisely, my lord, what I said. Now I stand by what has been actually written by the Honorable Division Bench, that the Honorable Single Judge was not right in dismissing at the very initial stage. 2, the Honorable Single Judge is required to decide on merit. 3, whatever the observations by the Honorable Division Bench been made across this entire order, the Honorable Single Judge would not be influenced by that. So therefore, my lord, in view of this Honorable Division Bench order, I would be requiring to use an affidavit in oppositions, for which I am seeking 4 weeks time, so that I can give my opposition. And the information, for this information, I am not seeking a time, because it is not odd. It would be odd on my part to seek time, because in case the commission becomes successful before the Honorable Supreme Court on this, then the Honorable Single Judge would not even be required to go on merit, because on the day one, my submissions before the Honorable Single Bench was that this is a kind of matter where there may not be any requirement of opposition and reply. But the Honorable Division Bench found no, this is not right. This has to be decided on merit, either this way or that way. So kindly grant me, my lord, 4 weeks time, so that I can use my oppositions. And lordship may record that that the commission is also contemplating to file an SLP to question this order dated 16th of 4, and that would be filed within 7 days. These are my respectful submissions.
But the order of the passed by the Honorable Division Bench on April 20, my lord, files an affidavit, my lord. that has not been complied, my lord, till date, my lord.
Which order?
My lord, the order passed by the honorable division
But
filed their affidavits.
that is a different matter.
সেখানেও
But that is a different matter. My learned friend is
connected matters, my lord.
the matter which was before the honorable division bench. In addition to all these directions, there was also that in this matter, I have to file an opposition for 4 weeks, but that was meant for that matter. But today, before your lordships, there is a different matter
But it-
where I am seeking. In any case, my lord, I have to now address on merit. I cannot take a technical point of delay, which I took. So for that, I am seeking 4 weeks time. It is not possibly unreasonable.
But this Manoj Chakraborty and others, is Soumendu Chattopadhyay is also a repetition.
But
here.
the writ petition, but the in Manoj Chakraborty, my lord, the petitioner earlier moved writ petition 20906, where my lord, the Soumendu was also petitioner, my lord.
No, question is whether before in the appeal, or Manoj was there or not. I don't think Manoj was
Not
there in
Manoj
the
there,
appeal.
but
That's
the
what I'm
writ-
saying.
Manoj was not there.
Manoj was not there as a party in that appeal.
But the honorable
Therefore,
division bench has,
Circumstances of Manoj Chakraborty similar to Soumendu.
my lord,
well, that
and
I have
all
to,
the petitions
no,
up to
but
15.
that's not possibly, it is nuanced. It is nuanced.
But the writ
There
petition
are
which is
variety of
recorded
persons.
by the honorable division bench,
In
paragraph 2, my lord,
Soumendu, well, there are variety of persons. In Soumendu, one of the reasons the honorable division bench found that this needs to be decided on merit, because there factually the honorable division bench found that those writ petitioner, I allege that they came after 5 years, but they were able to convince the honorable division bench that true, that this writ petition was filed after 5 years, but they also filed another writ petition which was within the period of, my lord, the panel life. So therefore, my lord, that is a factual point which might vary with many other petitioners. Just because someone is having a qualifications will not be the sole point of saying this is similar. There will be variety of factors which I have to decide in each of the
So
affidavits.
as far as the Manoj Chakraborty is concerned, simplicity, you are going to file an
Yes,
affidavit in opposition
yes,
to
yes,
decide on
yes,
merit.
simply,
What
yes.
is the writ petition item number of Soumendu today?
Showman 24096.
It is
Oh.
appearing in item
No,
number.
no,
Soumendu is
no,
appearing.
no,
I don't think
no,
Soumendu
Showman is not
is
appearing.
not
but
appearing.
WPA my lord, 243 of 2024, my lord.
243.
Of 2024, my lord.
No, that is not in the list.
No, সেটা
Ah,
my lord
that's
দিয়েছে।
absolutely.
Copy of the supplementary affidavit you have served.
Yes, my lord, on the last occasion, my
Mhm.
lord, I have served.
Mr. Pratik Dhar, learned senior advocate, appearing on behalf of the Madrasa Service Commission. Learned senior advocate, appearing for Madrasa Service Commission, seeks to file affidavit in opposition to the writ petition as well as to the supplementary affidavit. এখানে করুন, for the present writ petition, the petitioner seeks for grant of appointment in favor of the petitioners. How many are there?
My lord, 15.
Court fees you have paid for the petitioner.
So item number 10, 11, 14 also same, Lordship.
One after the other, all will be called. You wait for your turn.
But 14 petitioners.
14. You have filed a
But I have to check up, my lord.
okay.
Is it?
Petition, huh? 6 to file. Assistant teachers as successful candidates in 6th state level selection test, in short SLST, bracket close 2013, upon considering the B.Ed degree as trained candidates. Giving priority over non-trained candidates. Honorary holo. Let such affidavit in opposition be filed within a period of 4 weeks. A reply, if any, be filed within a period of 2 weeks. List this matter. Hearing a list to them 6 weeks for it.
Kindly fix any date, my lord.
After 6 weeks. Hold on.
But
9 September.
any time may be fixed. Any time. Subject.
Bolo time, bolo 9 September.
Come
From
যদি কোনো টাইম
কত বললো একটা বেশ
আমার কোনো আপত্তি নেই।
কবে
I have no problem.
ঠিক আছে 10th সেপ্টেম্বর
Fine.
3টের সময় দিয়ে দাও লাইব্রেরি আছে না দিলে না 3:30 হতে পারে 3:30 থেকে 4:30 হতে পারে
10.
3:30 দিয়ে দিই তাই এটা
Well
কত নম্বর
obliged.
4 up to 5 wait
My lord, I am not repeating my submissions, but these are same submissions for all.
No, I'm not recording that submission in this writ petition because whether they stand on the similar footing or not, because since you are filing a
I will
affidavit in
disclose
opposition, that
everything.
will
Correct,
Right.
correct. Lordship
if you
need.
take up Somendu Chattopadhyay in any other
Correct,
time,
correct,
we'll
correct,
record
correct.
that. This is also same
My lord, this is all up to 15 minutes.
same order same order
What happened?
আচ্ছা ওখানে না একটা লাইন অ্যাড করে দিন যে advocate on record for the petition is directed to furnish ad valorem court fees
My lord, here also my lord, the single petitioner, my lord.
ad valorem in the earlier one ad valorem court
Right.
fees if not already paid
Right.
same order করবেন ওখানে যে ad valorem court fees টা দেবেন all will appear on ওই ডেটে same ডেটে নিয়ে এসো Mr. Dhar
Yes, my
the
lord.
issues from 4 to 15 are all same
Yes,
Okay.
yes.
Preference, my lord.
Issues same. In fact, when
Preference
Lordship
for
would be
having training
taking up the main matter, factually it will not take much time because it is purely point of law.
okay
Whether it is a judgment on rem or judgment of personam, that would be one issue. The other issue would be
Whether
whether those relief which was given based on a judgment in my submission ignoring an existing honorable division bench judgment, because one of my merit submissions would be there was an existing honorable division bench judgment. Incidentally, there the then honorable judge happened to be on my other side, and I was there also. There, the honorable division bench took a view and gave a very interesting definition of preference. There, that the honorable division bench said that preference would be applicable if if two persons are equal, getting same number. In that case, someone having the B.Ed qualifications, he would get a preference. So preference is not like as if completely taken a march over someone. Similar order, similar marks, but someone B.Ed, he will go. But that's a division bench that was never placed at all.
my lord, another point, my lord, since the order passed by the honorable single judge directing to preference has been affirmed by the honorable Supreme Court, my lord, whether the issue can be reopened, my lord, since the order has been affirmed
Correct,
by the
correct.
honorable
That would
Supreme
be whether
Court, and whether the judgment has a retrospective effect or prospective.
all the law points. No disturbance on fact.
okay next
Uh,
next doc
One thing, my lord, my lord, I have prepared one compilation with
Don't
all
give
rules-
today because today
rules and all the judgment passed by the honorable single judge, my lord, and up to the Supreme Court, my lord. That
ultimately job in দাও
এটা কি চাই?
আমাকে দিলে সফটে দিলে ভালো হতো ঠিক আছে I will take.
চারটা।
Homendu is appearing monthly list
No, it is not appearing.
give the number on Friday
Right.
থেকে নিয়ে এসে এক জায়গায় নিয়ে আসতে হবে
হ্যাঁ 240
same one in 6 how many petitioners are there 1 7
Even my lord, the others, Kaji
7 এর clause টা দিয়ে দেবেন if not paid ad valorem court fees 6 weeks
3 petitions. 243 নাম্বারটা কি রাজকুমার হচ্ছে 2
8.
Eight, and two petitioners. Rajak Sheikh.
Same order, same.
But in Rajak Sheikh malad, I have taken out a supplementary malad affidavit that may be written with the
Supplementary affidavit on the prayer of learned advocate for the
জানি।
petitioner, leave is granted to file supplementary affidavit. Let such supplementary
এটা হচ্ছে
sorry,
Rajak Sheikh
supplementary
হচ্ছে
affidavit
আপনার,
filed on behalf of the petitioner
9
is taken on record, copy sir.
এইটা
Mr. Pratik Dhol, learned senior advocate appearing on behalf of the
but I have already served.
Madras Service Commission seeks to file affidavit in opposition to the writ petition as well as the supplementary. The rest same.
একের গুলোয় প্রথমটা দেয়া।
10 is mine, Lordship. Item number 10. Only one petitioner.
না এটা কত হচ্ছে আর 9 হয়ে গেল। চেক করে নাকি যেন 10-11 তো আমাদের নয়, 10-11 আমাদের।
YOLO.
9 এ দিয়েছি। রাজ্জাক শেখ 9
কোনটা লিড মামলা আপনি বলে দিই তাহলে সেটাই
হ্যাঁ হ্যাঁ ওই
Nine. 10.
Whom for the petitioner, Lordship?
You are appearing for the petitioner.
I appear for the
No,
petition.
let's take the Sami Mamla, Lordship.
Similar issue is involved.
Okay.
না এটাতে কোনো
Give
সাপ্লিমেন্টারি
your, give your affidavit. Affidavit of service. Give the similar submission.
সিমিলার
Same order করবেন. File the affidavit of service.
Right.
Mr. Ahmed, Samim Ahmed, learned advocate for the petitioner undertakes to file the affidavit of service on
By
the
Friday,
returnable date.
Lord, my junior is not here. By Friday, I shall be blessed.
On the returnable date. File that.
ইভেন বেটার
Next. No, there is no supplementary in this.
No.
11. You are appearing 11? Same করে দিন। Same thing, এতে affidavit সে থাকবে না। Already same. How many are there?
ওই আমি অপোজিশন দেবো মেরিট
13 millet, similar matter millet. Supplementary was filed, possibly not recorded in the order millet. Oh, recorded.
13.
Yes, yes. No, millet, it was recorded.
আছে
They will be filing affidavit millet in respect to writ petition as well as supplementary millet.
অর্ডারে সেটাই বলা আছে যে
এটাতে বোধ হবে হ্যাঁ?
Similar millet.
এটাও সাপ্লিমেন্টারি আছে
14 there is supplementary?
No.
Okay.
Safe. এখানে ওই ক্লজটা দিয়ে দেবেন if not filed. বুঝিত বাবু এখানে ক্লজটা কোর্ট ফিজের ক্লজটা দেবেন।
ভালো অবলাইজড
ওকে
ফাইভ আলাদা দিয়েছি 6 to 15 একসাথে
তিনটা দাম আর
বলছি
16.
My lord, on last occasion, order was given to serve copy upon us, your lordship. Copy is not available, not Sarthak, your lordship. So that has not been supplied
Yes.
us.
You have not served?
No, but already order করা হয়েছিল।
Yes, the report is ready.
Your lordship had directed them
My lord, that
serve a copy upon the state.
copy is not available on Sarthak, your lordship also.
Serve the copy.
Have served the copies. Your lordship passed the order on earlier question to file a report.
Where is that? That you have served?
Service to the- This is not.
Serve to the learned advocate who is appearing.
But it's
Serve to the learned advocate who is appearing in court because learned GP has told me that he is not assigning the matters.
lordship.
So
I-
once you serve in the office, that will remain in the office. It will never reach the learned advocate. So do that. If you have a copy right now, you serve upon Mr. Singh.
My lord.
If you have a copy, give
Lordship,
it.
I'm by in course
Mr.
of
Parthu-
grace serving a copy.
Mr. Partho Sarathy Dev Burman, learned advocate for the petitioner, undertakes to serve copy of the writ petition upon learned advocate for the state.
তোমরা তো দেবে না
29 মানে এই 8 থেকে 29 কত দিন হচ্ছে 3 weeks এর 8 তারিখে এসেছিল
In course of day, I will serve the copy.
undertakes to serve in the course of the day. State is directed to furnish report in terms of order dated 1st April 2026 by the returnable date. List this matter. August end রাখো। After 2 weeks, 3 weeks পর রাখো। 26th August. কি হয়েছে দেখি?
বলছি নাকি
Matter was hard attended.
Take instruction. Yes, yes.
Before your lordship. And my lord, my specific case is that my lord,
They have given a post facto approval. Now they say that you have no
Yes.
prior.
and I have shown the judgment special bench as well as division bench judgment.
My lord, I would like to trouble your lordship. Just please come at the last order dated, your lordship, 15th July 2026, para number 3. Mr. Shaumin Kumar Dasla, learned advocate appearing on behalf of the petitioner, submits that the petitioner was permitted by the managing committee to pursue master in history, your lordship. And now, your lordship, we are going to submit our report. So, that is not a fact at all, your lordship. The petitioner was never permitted to for this course, your lordship.
You cannot give prior knowledge in the office at that time. Yes.
One by one, this document which I annexed. First of the managing committee has given me permission. Page 20, resolution 21, para 6. Kindly see.
Page 20.
20 resolution, relevant page 21, paragraph 6. অদ্য সভায় মাদ্রাসা সহশিক্ষক আব্দুল কালেক খান সাহেব বিষয় হিস্ট্রি অনার্স এসএসসি হইতে
আবেদন
অনার্স
করেছেন,
পেলে এই মাদ্রাসার বর্তমান কর্মরত
অনুমতি
উনি
দেওয়া
মাদ্রাসা
হইল।
যথারীতি ক্লাস করে নেতাজি সুভাষ মুক্ত বিদ্যালয়ের যে দূরবর্তী শিক্ষা ইতিহাস বিষয়ে এমএ পড়ার জন্য আবেদন করেছেন। ওই আবেদনের পরিপ্রেক্ষিতে উক্ত শিক্ষককে এমএ পড়ার অনুমতি দেওয়া হইল। This is the first permission was given to him. You go the higher study for MA in history. Now, my lord, thereafter next page, the teacher in charge issued a letter to the DI for seeking permission. Kindly see. Therefore, I earnestly request you to give him permission for doing MA in history. This letter was issued by the school authority to the DI for seeking permission so that he can undergo the higher study. Thereafter, my lord, the DI totally remained silent over this issue. He did not give any permission. But to that respect, my lord, I have shown a judgment 2013 to CHN. 2013 to 2013 to CHN.
13.2.
13 to CHN of page 632.
Judgment গুলো কোথায় গেল?
2013 to CHN is 632. My kindly, I am giving this book.
13 to CHN 632. Yes.
No, CHN. 632. Now, kindly see paragraph 11, 12, 15, and 17. I am reading that. Mr. Moitro further submits that an appellant of the petitioner herein duly applied before the district inspector of school SC Paschim Midnapur, seeking prior permission for obtaining the higher qualification, namely postgraduate degree in mathematics. From the records we find that the secretary of the managing committee of the school concerned by the written communication dated 3rd January 2006 had forwarded the prayer of the appellant of the petitioner for granting permission to undergo MSc course in mathematics subject. The managing committee of the school also passed a resolution allowing him to undergo the aforesaid MSc course in mathematics, but the said resolution was forwarded to the district of school. Next, the district school concerned, in spite of receipt of the aforesaid communication, did not refuse the prayer made on behalf of the appellant or petitioner or the school authority for allowing the said appellant to undergo the postgraduate. Therefore, school made an Therefore, the school adopted resolution, forwarded the application to the DI along with the resolution, but the DI did not take any step, sitting idle over this matter. Next, paragraph 15. Mr. Moitra also submits that para 3 of the aforesaid circular dated 27 November 2007 cannot override the provision of the West Bengal Control Expenditures Act 2005. Next, para 17. It is true that a circular cannot override the specific provision of the Act. In the present case, the appellant petitioner was admittedly appointed in the school as honors graduate with BA degree. As a matter of fact, at the time of joining the school, qualification of the appellant was honors graduate in mathematics and BA. Subsequently, the said appellant acquires postgraduate degree. Therefore, in terms of the 14(3) of the West Bengal Control Expenditure Act, appellant herein is entitled to draw the postgraduate teacher. Furthermore, para 3 of the office dated 27 November 2007 has not been specifically violated in the present case, since the appellant has sought for prior permission from the district inspector of school for undergoing postgraduate study, though the managing committee of the school had such permission was never denied by the district inspector of school. Considering the aforesaid fact, we are of opinion that the district inspector of school should not have rejected the claim of the appellant petitioner for higher pay even after acquiring the higher qualification. This is. Therefore, the DI did not give any response to the application forwarded by the. Now, here I have shown to your lordship the teacher in charge has forwarded the DI. DI totally Kalyan over this matter. Thereafter, he took admission in MSc, MA, and thereafter he passed in 2009. Now, thereafter, he made an application for a higher school of pay. After my lord giving that, I made an application also. You give the higher school of pay. That was recommended by this school authority. Now, post facto has been given to me. Now, 27 November 2011 circular, when I am giving that, headmaster manager, the circular, what is that? The contents of that circular?
Page number?
Page 1039. Page 1039. It is actable. This 1039.
What is the impugned letter is at page P15,
Impugned, my lord, impugned.
48, page 48.
Page 48. Now, this was rejected on relying upon that 27 November 2007. Right hand side, bottom.
593.
593. Now, can you see the
All
Reference to
teachers.
no, circular? So it is reference किसे? No, the prior the permission.
Is from the managing committee, not from the DI.
Yes. DI, my lord, has rejected my prayer, relying the circular dated 27 November 2007. Here, my lord, the permission has been given to me. Post facto permission. Now, the judgment which I have cited to your lordship, in that judgment, my lord, the prior permission was not given. Only the application was made by the school authority to the DI for seeking permission. The division bench held, when the application was forwarded to the DI, you see title over this matter. Now you cannot refuse the high scale of pay. Here, my lord, I am the last point. I have been given the post facto permission. Now, my lord, the division.
They are denying in the report that that is infructuous in view of 593.
Yes. 593 circular, my lord.
Come to page 9 of the report.
My lord.
Page down. Last page, my lord.
No.
There is
First page.
paginess in my report.
First page of the report, paragraph 9.
First page. But 27 November 2007 is not applicable to me.
Because you have taken permission.
It's not applicable.
Okay, Ashok.
And my lord, this judgment, the special bench judgment, is very clear. I have shown to you last the
Give that.
judgment, my lord. 2025. Volume 4 CH. বই আছে 550 550 মানে খালি সিডি চার্জ paragraph 182 and 184 paragraph 84 also. Very important. A teacher with honors graduate degree shall be entitled to postgraduate scale pay upon acquiring the postgraduate degree without there being a requirement of any prior permission. And 14.3 is the mandatory, 14.3 of the West Bengal Control Expenditure Act.
This also applies in case of the petitioner.
And you also kindly see 14.3, well, kindly see, give the headmaster's
14.3 has
manual.
been
I will
quoted
show-
in the judgment CHN.
No, no, my lord,
14.3.
headmaster's manual, I will show to your lordship the West Bengal Control Expenditure Act 14.3. This is very important. And circular cannot override the statute. There is specifically kindly see 14.3. একটু just that. I have given a remark. Left hand side. What?
এটা রাখুন আসুন report filed by the state respondent is taken on record, copy served. By the present writ petition, the petitioner seeks for setting aside and or cancellation and or withdrawal of the order dated 1st June 2026 issued by respondent number 3, District Inspector of Schools, AC North 24 Parganas within bracket annexure P15 to the writ petition, and for grant of higher scale of pay in favor of the petitioner for acquiring MA in history on and from 1st July 2010 is the date on which he has passed.
Hello?
You have asked for higher scale of pay from 1st July 2010. It is the date on which the results have been declared.
No, no, from the date of, this is circular states down from the date of the last examination. Now, since from July, in every year, the increment is done. That's why from July.
Okay. Now, he has completed his course on which date?
My lord?
He has completed on which date?
2009.
9. On and from 1st July 2010. The petitioner contains that the petitioner joined as an assistant teacher in history in Bargachia Adorsho High Madrasa within bracket HS on date of joining
On page 18, this is my approval letter.
on
8th May 2003.
8th May 2003. He joined on 8th May. 8th May 2023. 23 have written.
Page 18, can you see page 18? 2003.
And the second paragraph, there is a wrong mistake in the date. 2003. In the writ petition, there is a mistake.
I have annexed the approval letter.
Eighth May 2003. In the year 2007, the petitioner made an application before the Secretary of the Managing Committee. Secretary of the Managing Committee.
Fine.
Secretary of the Managing Committee of the said Madrasa for pursuing MA in History through distance education from Netaji Subhas Open University. Stop. On 5th April 2007, such application of the petitioner was considered by the Managing Committee, which adopted a resolution permitting the petitioner to pursue higher studies in MA in History. By a forwarding letter dated 12th April 2007, the teacher in charge of the said madrasa sent a copy of the resolution to the district inspector of schools seeking permission in favor of the petitioner to pursue higher studies of MA in History. In the meantime, the petitioner obtained the master's degree in history in the year 2009. On 10th February 2014, the petitioner made a prayer before the Secretary of the school, madrasa, or managing committee. What is this?
Managing committee.
Managing committee for sanction of postgraduate scale of pay. On 22nd February 2014, the petitioner was recommended for higher scale of pay in view of enhancement of higher qualification by the managing committee of the school. P-Day, its resolution taken on the said date. Post facto approval, page number?
Page 42.
The district inspector of schools did not refuse the prayer of the petitioner seeking for permission to pursue postgraduate degree in history. Page 22.
Page 42. Well.
42. Post facto approval was granted to the petitioner by the District Inspector of Schools AC North 24 Parganas on 31st October 2019. However, by later dated 1st June 2026, the District Inspector of Schools AC North 24 Parganas informed that he is not in a position to take into account the post facto permission for allowing PG scale to the petitioner. Being aggrieved and dissatisfied with such action of the respondent authorities, the petitioner has preferred the present writ petition. Mr. Toumen Dotto, learned advocate appearing for the petitioner, submits that the petitioner was permitted by the managing committee to pursue master's degree in history, and such recommendation was forwarded to the District Inspector of Schools AC North 24 Parganas. The District Inspector of School never denied any permission to the petitioner, and the recommendation of the managing committee was kept pending. Upon completion of the master's degree in history in the year 2009, the petitioner made application seeking for grant of higher scale of pay. Relying on the decision of Honorable Division Bench in Akhtar Hossain Chaudhary versus State of West Bengal, reported in 2013, Volume 2, CHN Calcutta 632. He submits that if on receipt of the recommendation, the District Inspector of Schools did not refuse the prayer of the petitioner, subsequently, the District Inspector of Schools cannot refuse to grant postgraduate scale of pay. Moreover, when the managing committee has granted permission to the teacher concerned for acquiring higher qualification in the relevant subject without affecting his duty as a teacher of the institution, the District Inspector of Schools shall not deny the benefit of higher scale of pay merely on the ground of failure to obtain prior permission. To buttress his contention, he relies on the decision of the larger bench of this court in Utpal Kanti Karan versus State of West Bengal, reported in 2025, Volume 4, CHN within bracket Cal 550. Further, relying on Section 14 within bracket 3 of the West Bengal Schools within bracket Control of Expenditure Act 2005 is hereinafter referred to as the Act of 2005. He submits that every teacher of a school shall, if appointed in the honors graduate or postgraduate teacher category, be entitled to draw pay of postgraduate teacher category upon acquiring postgraduate degree. He also indicates that the petitioner has been granted post facto approval by the District Inspector of Schools, and therefore the District Inspector of Schools cannot deny to grant higher scale of pay to the petitioner in such circumstances. He seeks for setting aside of the impugned order dated 1st June 2026 and for grant of higher scale of pay in favor of the petitioner on and from 1st July 2009. 2010. On the contrary, Mr. Brijendra Pratap Singh, learned advocate representing the state respondent, submits that the petitioner is not entitled to higher scale of postgraduate scale of pay since he did not pursue such course upon taking prior permission from the District Inspector of Schools as required under memo number 593-AC within bracket B dated 27 November 2007, which mandates of taking such prior permission. Therefore, the pursuance of higher degree, postgraduate degree by the petitioner violates the existing notification/circular of the Government of West Bengal. He seeks for dismissal of the writ petition. Upon hearing the learned advocates for respective parties, the only issue which falls for consideration is whether the petitioner is entitled to grant of postgraduate scale of pay or not. ওই বইটা একটু ছেড়ে দাও। 593 just placed that book 593 ওই ভলিউম বইটা কোথায় গেল? In order to examine the aforesaid issue, it would be apposite to reproduce the notification number 593 ACB dated 27 November 2007, which reads as follows. All the teachers, para 1, all the teachers teaching in different state aided schools will have to take prior permission from managing committee / ad hoc committee / administrator as the case may be to enroll themselves and to appear for any examination for enhancement of educational qualification. Stop. The managing committee, being the competent authority in such cases, will take a decision in its next meeting and convey its decision to the teacher concerned immediately. A copy of the decision of managing committee will be forwarded to the office of DI of schools AC of the concerned district. Para. From the materials on record, particularly the resolution dated 5th April, page number, Mr. Dotto, 5th April.
Prior permission.
No, the resolution is at page number
Giving that.
5th April.
Page 20.
11
page 21. Para 6.
Particularly, resolution dated 5th April 2024, the petitioner was permitted by the managing committee to pursue MA on the relevant subject. It was also resolved that such resolution will be forwarded to the District Inspector of Schools AC for necessary permission. In compliance thereof, the teacher in charge of the ওই ওপরে না said madrasa করে দেবেন তো আদর্শটাকে of the said madrasa sought for permission from the District Inspector of Schools, North 24 Parganas, on behalf of the petitioner to pursue MA in history. From the aforesaid chronology of facts, it manifests that the requirement of 593 AC within bracket B such notification dated 27 November 2007 has been complied with by the managing committee as well as the school authority. Para. Needless to mention that the district inspector of schools did not take any decision on the recommendation made by the managing committee to the petitioner granting permission for pursuing masters in history. At this juncture, it will be profitable to reproduce the observation of Honorable Division Bench in Akhtar Hussain Chaudhry Supra as hereunder. 8 of them, 13 and 14. Bearing in mind the aforesaid observation, this could find substance in submission of Mr. Dotto that the district inspector of schools cannot deny higher scale of pay when it did not refuse to grant permission at the material point of time. It is also relevant to note that VDA post facto approval page number
Page 42.
VDA later dated 31st October 2019, post facto approval was granted to the petitioner. Moreover, Rule 14, Section 14 within bracket 3 of the Act of 2005 provides that every teacher of a school shall, if appointed in the honors graduate or postgraduate teacher category, be entitled to draw pay of postgraduate teacher category upon acquiring postgraduate degree in the manner as may be specified by order. এটা উৎপল এ থেকে না উৎপল কান্তি করণ থেকে পেজ প্যারাগ্রাফ 182 and 184. You are referring to 182 and 184?
My lord.
Okay, 184 টাকে সেট আউট করবেন। Bearing in mind the aforesaid observation of the larger bench as well as the provisions of Act of 2005 as enumerated above and the observation of Honorable Division Bench in Akhtar Hussain Chaudhry Supra, this court is of the view that the order impugned of district inspector of schools dated 1st June 2026 rejecting the prayer of the petitioner for grant of postgraduate scale of pay is liable to be set aside. Accordingly, notice such and such is set aside. It is in the above conspectus, the petitioner is entitled to postgraduate scale of pay from this will from 1st July,
July 2000.
1st July 2010. The district inspector of schools is directed to a formal order is to be issued from his is directed to issue a formal order granting postgraduate scale of pay in favor of the petitioners on and from 1st July 2010 and also pass consequential orders. Granting arrears in favor of the petitioners. With the above direction, the petition stands
Within certain time.
within a period of 6 weeks from date of communication of this order. Give a copy of 593 and the portion of 182 and 184 because this is the judgment. আর এটাকে দিতে বলবে এটার ফটোকপিটা দিতে ডিসপোজ অফ
Let's do this.
next
And I'm
Yes.
the respondent of 5.
My lord, I'm for the petitioner.
cancellation of order dated at this state.
My lord, in this case, the petitioner is challenging the appointment of the respondent, private respondent number 5 as the headmaster of one school. My lord, let me,
Is appearing for private respondent.
I'm for the private. Respondent of 5.
Private respondent.
Yes, madam.
My lord, I am for the
Cool.
respondent number 6.
my lord, let me explain the facts of this case. Now, in Chabdani Hooghly, there is one Islamic educational and welfare trust, under which there is one school called Ikra Model Academy School. The petitioner is one of the former students, one of the former teacher, as well as one of the beneficiaries of the trust and the local guardian of one of the students. My lord, the petitioner has stated in paragraph number 5, in page number 5, points A, B, C, D, how the private respondent number 5 is engaged in illegal activities in the school, my lord. In point number A, he has stated that
Point number
5 has forged and manipulated the records and registers of the school. Also in the
Whose private respondent number is headmaster.
yes, my lord, he was the headmaster. In point number C, he has stated that in terms of the trust deed of the welfare trust, a member of the trust cannot be an employee of the trust. In the same manner, he has also stated that the date of joining of the private respondent number 5 is 24/12 to 1989, which was a Sunday. My lord, the petitioner being aggrieved has stated all these illegal activities of the private respondent number 5 in a representation, and he made the same to the concerned respondent authorities, after which he filed a writ petition in 2019, my lord. In 2019, this honorable court was pleased to pass an order and dispose of the case, stating that the petitioner will make a detailed representation and send it to the concerned respondent authority, and the respondent authority will pass a reasoned order within 6 weeks. Now, my lord, in the reasoned order, the concerned respondent authority stated that in 2012, a same writ petition on the same cause of action was filed by one Hassan Javed, which was not allowed by the High Court. Therefore, we will not go into the merits of the case. Being aggrieved, the petitioner again filed a writ petition in 2021 against that reasoned order, in which this Honorable High Court directed the respondent authority, the concerned respondent authority, to consider his representation dated 10th July 2021 and pass a reasoned order. That reasoned order was passed.
2019.
Yes, this is the,
Representation is 10th July 2019.
yes, 10th July 2019. In the writ petition of 2021, this honorable court asked the concerned respondent authority to reconsider that 10th July representation and pass a reasoned order. The reasoned order was passed on the 2nd of June 2025, against which this writ petition, current writ petition, has been filed. My lord, it is P5. I have annexed it.
Neither a former teacher.
My lord, in page number 49, the concerned respondent authority has stated that the private respondent number 5 has already superannuated from his service on the 31st of March 2025. Therefore, we cannot take any action against him. But
That has not been written.
my lord, it is written in page 49, fifth paragraph. However, the main prayer, that paragraph, my lord, page number 49, that he has already retired from his service on 31/3/2025. Therefore, we cannot take any action. However, if my lord kindly notices the last sentence of this paragraph, though the date of initial appointment is 24/12/1989 of the respondent number 5 as a teacher, being a Sunday is questionable. His date of joining is a Sunday, which is questionable. But the petitioner got no relief, my lord. A criminal case is also pending against the private respondent number 5,
Okay.
which is annexed in the next page, my lord, page 50. So that is the prayer of the petitioner, my lord, that the headmaster, the former headmaster, was engaged in illegal activities and he had a false appointment, my lord.
False appointment, this has been approved by the authority.
Yes, but they are admitting that it is questionable that he was appointed on a Sunday. Back in 1989, my lord.
His joining is questionable, not
Yes,
his
my lord.
appointment.
Yes, joining was questionable.
But it has been approved. A DLIT report has been, upon the DLIT report, his approval has been made by the authority and he is qualified as approved. This was, it says
qualified.
that this was never challenged. The approval was not challenged.
But no relief can be provided to the petitioner at this stage,
Yes.
as he has already retired. My lord, so he has made 3 prayers. One is rescinding this impugned order, that is the reasoned order dated 2nd of June 2025, to take action against the illegal activities of the private respondent number 5. And my lord, to withhold his terminal benefits until the criminal case is decided. These are the 3 prayers he has made in this writ petition.
What is your locus?
I am one of the beneficiaries under the trust.
Where is that?
My lord, he has not annexed. This is a transfer brief. He has not annexed the paper.
But then anybody outside the school comes up with a prayer before the court that you stop the retirement benefits to the person having low locus.
He has not annexed any annexures, but he has stated that he is one of the beneficiaries, one former student, one former teacher. In paragraph number 1, my lord.
It is countered that as per the admission register of Farhan Mumtaz Ansari, there is no reflection that the petitioner is the local guardian of the said student.
Yes, my lord.
So how do you prove that you are the local guardian? You have filled in that application.
My lord, in paragraph number 2.
You have filled the application on behalf of the student, showing yourself as a local guardian of them.
He's stating that he is a local guardian.
He is stating means that has to be proved before the court by any document that
If your
Since he is a local guardian, he is affected by the steps taken by the erstwhile headmaster.
if your lordship can kindly grant me some time, I will try and get the.
You first satisfy para 1. Right. Para 1, you have said former student. Now you are saying that he is also former teacher of that school
Teacher of the school, former student, as well as
and
one of the
also local guardian,
and a beneficiary.
beneficiary of the trust.
Yes, my lord.
Produce the documents and
Not
so
documents.
also produce the relevant rules wherein a retired teacher against whom there was a complaint, this can be withheld. What does the rule says? What is the provision? What is under which provision this will be terminated?
If your lordship kindly grants me some time, then I will try and get the relevant documents, my lord.
It says that as per guidelines of SISU SSK issued with a memo number such and such to initiate any disciplinary action against respondent 5 after his superannuation, there is no provision. Right.
Yes, my lord.
So if this order you are challenging that this order is illegal, then you have to base on certain rules that it has not been followed, that rules and the order has been passed. Correct? To go through that. Yes. Let her go through that. Let her place her case in the next week. We'll see. Affidavit of service filed on behalf of the petitioner is taken on record. Miss so and so learned advocate appearing for the petitioner seeks accommodation. Is this matter? 2 সপ্তাহ পরে রাখি নেক্সট উইকে রেখে দেবো 5th
August.
But my instruction, my lord, day before yesterday, একটু বলে নি? Day before yesterday, we approached the director of Madrasa Education matter. He assured me within 8 or 10 days, my lord, they released my outstanding honor.
modifying this,
My lord,
modifying the date.
my lord, 8 to 10 days, my lord,
Mr.
assured, my lord, he assured.
Mohammed Kutubuddin, learned advocate for the petitioner, submit that
report, your lordship, just
report filed by the state.
আমাকে দিয়ে দেবো
Which record? There was a report.
ঠিক আছে।
আগের কি ছিল? আগের দিন কি দিয়েছে?
এখানে দেবে কিছু বলেছে?
A report filed by the state is taken on record. Mr. Mohammed Kutubuddin, learned advocate for the petitioner.
না আমি কত সোমবার আমাকে বলেছে হ্যাঁ যে আপনার এটা এ হয়ে গেছে অ্যাপ্রুভাল হয়ে গেছে দিয়ে দেবো
Submits that the concerned department is has SEO for rectifying the approval of the petitioners. He seeks 2 weeks accommodation. 2 সপ্তাহ পরে.
Well, kindly 2 weeks, my lord, after my.
After 2 weeks, this will appear.
I'm good.
I have recorded your submission that they have given an assurance.
Fine. I'm good. I have received my report. 12 August. I'm good.
And I'm for the writ petitioner. My lord, I am non-teaching staff in the madrasa and I am still in continuous service in the said madrasa for 30 years without any break. My lord, this is the fourth time litigation filed by me and the impugned order herein is at page 90, my lord. Page 90, annexure PIP. And after 3 battles of litigation, my lord, the Honorable Justice Devashish Korgupto in WP number 17285 of 2014, my lord, headline, my lord, page 90, was pleased to direct the district inspector, director of madrasa to pass a rescind order to consider my case. And the said director passed a rescind order, and wherein the said director admitted that I am in service without any break. But on the last paragraph said that in the DLIT report my name was not there, and for that he cancelled the same. My lord, I will place the report, my lord. My lord, kindly give me time, my lord. Kindly come to page 88, my lord. Page 88.
Who is the answering respondent is the state?
Is the director of madrasa.
State.
State. I do not know whether my friend is appearing.
No, we have already appeared in last occasion, your lordship, but petitioner were not, didn't appear to your lordship.
Oh, on the last
Please.
occasion I was absent, but earlier it was placed.
Earlier state
before
was
the
there.
election, before the election, my lord.
Now the
My lord, I
copies,
want to place the said director's report
wait,
afresh before your lordship, my lord. Kindly allow me.
reply, wait,
My lord,
reply,
in the-
wait, sir, reply and exceptions all have been filed.
I have filed the reply. My
Give him
lord,
a
the
copy.
earlier advocate filed a report of the
Give him
DI.
a copy.
My lord, just humbly praying to serve a copy of honestly, your lordship, because we have.
Provide the copy of the pleadings to Mr. Singh,
My lord, of the
learned advocate for Mr. Brijendra Pratap Singh, learned advocate for the state respondents, seeks that the copy of the writ petition and the other pleadings be served upon him, learned advocate Mr. Molloy Roy, learned advocate for the
My lord.
petitioner, undertakes to serve such copies
My
of the
lord, give me
pleading
spot
to
date, my lord.
within
Next Wednesday.
today you can serve.
My lord.
Today you can serve the copies.
My lord, I can serve.
Oh, in the course of the day.
I can serve, my lord.
Is this matter after 2 weeks?
In course of the day, my lord. Next Wednesday, my lord. My lord, kindly
2
give
weeks.
it, my lord. I am suffering. He is a very poor person, my lord, coming every day, my lord. Very, I must say. On the next Wednesday, my lord, if possible.
After 2 weeks.
As you like, my lord.
No, I am for the petition.
Yes.
Petitioner retired from service, my lord, December
Where is
2025.
your report?
And my lord, directed survey report.
Give the report.
Sir.
What is your prayer?
My prayer is to release the pension, my lord. Here,
The retired in favor of the petitioner who has retired. What is in the report? Why this has not been released?
ground for non-consideration, the claim.
The assistant teacher. He was sanctioned postgraduate scale of pay. Being a pension.
Did not have.
checking some objection raised.
কি রে ভাই, এই উল্টো পাল্টা জিনিস লিখেছে। PADD and this.
Around the last pair of the
My lord, your lordship
report, your lordship.
will
Draft
find
plan
that I am
effective.
not getting pension as a result. I've come before your lordship. Reason of
In parts
not releasing.
raised, part C and part D, date of effect of B8 is needed to review. A from first
দেখেছি দিনদালে এটা হবে না, এটা হবে না।
come to paragraph
Lord,
5.
what has happened, my lord? Page 20, your lordship kindly find my read petition. DI has sanctioned the postgraduate scale of pay. Your lordship kindly see page 20, annexure P3.
Yes. Yes.
Then, my lord, what has happened, my lord? The petitioner, my lord, he without B.Ed, my lord, he entered the school, my lord, and there is a provision, my lord, your lordship kindly turn page P5, page annexure page 22. There is specific direction that you have to complete the B.Ed within 5 years, 3 years. Your lordship kindly see
22.
page 22.
In reference to this, on the other subject, the understanding right to see as per the rules of the first 5 years of service, they have to complete 5 years.
Yes, within 5 years. my lord.
5 years.
Within 5 years. My lord, what has happened, my lord? Within 5 years, my lord, I got B.Ed, my lord, we are also page 20, page 21. There is no fault of my page 21. Declared pass in 2012. Bottom, see the bottom of page 2012.
Yes, B8.
So, my lord, when I've complied all the formalities, then, my lord, now my learned friend says, my lord, he's not entitled.
Come to paragraph 5 of the report.
My report just now I received the report, my lord. If necessary, my lord, I will give the some exception, my lord. Paragraph 5.
Paragraph 5 has indicated the audit observation. What is to be done? In this case, he says that part C and part D dated of effect of B8 is needed to be reviewed. Needed to review.
So on my part, there is no latches on my part, but it's a different. It is not the school authority will submit the report because, my lord, I have not done anything wrong.
Okay. You go through the report if exception is required or make your submission with regard to the
give some exception, my lord. Just now I
the report filed by the state furnished by District Inspector of Schools AC Kolkata date 22nd July 2026 is taken on record. Mr. Suensula, an advocate appearing for the petitioner, seeks to file exception to the report. Let such exception be filed within a week. Within a week.
Yes, within a week. But one thing is, my lord, I am entitled to get even, my lord, the provisional pension. He's not getting pension.
Within a week, list this matter on. Bolo. Date bolo. 5th August.
5th August.
5th August এক সপ্তাহ কোথায় হচ্ছে Fifth. Mr. Singh, you just find out from the department, in paragraph number 5 states that it has to be reviewed. Now, who will review that?
Yes. But till today, my lord,
The
I did not-
documents, B.Ed is there, the postgraduate degree, postgraduate scale has also been granted to him. If any review is from your end, you review that within a stipulated period and grant him the pension. Who will review that? Go through that. Exception 5.
I'm deeply obliged.
21. None appears on behalf of the petitioner. Copy has been served.
No, my lord, copy.
None appears on behalf of the petitioner. Or any accommodation is sought for ends of justice, state is represented, for ends of justice, the matter is adjourned, release this matter after 2 weeks. 2 সপ্তাহ পর রেখে দিন।
My lord, in item 22, my lord, I appear for the Madrasa Service Commission.
My lord, the representation was made for, my lord, regularization of the service of the petitioner, my lord. That is yet to be responded, my lord. Our prayer was that, my lord, let that representation be considered.
My lord, this is it's very nice of my learned friend because he is so intelligent. He diluted and made it's a very short point, but I have to say the law. My lord, what my learned friend is seeking today, in fact, I wrote down the date also. There was a large number of matters involving the identical question which was pending before the Honorable Supreme Court, presided over by the Honorable Justice Dipankar Datta. Now, the bench presided over of Justice Datta delivered an elaborate judgment. The fundamental points which were required to be decided by the Honorable Supreme Court were: 1, whether a regularization is permissible after coming into operations of the Madrasa Service Commission Act. In this writ petition, his fundamental point is that he is serving from 2011, that he claims. And then he is referring to a vacancy which has occurred in 2021. Now he is seeking that he may be accommodated in that vacancy. That's his sum and substance. He is asking, there is a representation, so let it be considered. Now, why it cannot be done at all considerations? Because Lordship may kindly have a look at this judgment upon the law 23. Can be. ওটা দিতে হবে না এখানে? Well, Lord, there are several provisions which might be required. First, Lordship, kindly take the definitions are in Rule 2. Under Rule 2, kindly take Roman 16, the definition of post. Lordship will find there post means, Lordship has got post.
Yes, yes.
Post means a full-time sanctioned post of madrasa of any of the following. Well, thereafter teaching category, etc., etc. This is concerned with under 2C, Group D peon. Lordship may kindly mark that. Then kindly take the definition of vacancy. This is 24.
Yes.
Vacancy means a vacancy in the post of teacher, including headmaster, headmistress, superintendent, or non-teaching staff, including librarian caused by number 1, creation of new post, which is not the case here. Number 2, superannuations of a teacher or a non-teaching staff. This is the case that there was a superannuation in 2021. There is a vacancy. That then lordships kindly take rule 8(1). Once, my lord, I am trying to go exactly the way his petitions he has stated that there was a superannuation. So therefore, the moment there is a superannuation under the rule, that is recognized as a vacancy. And after it is recognized, kindly come to under rule 8. The commission shall publish at the time of publication of advertisement for the concerned state level selection test the total number of tentative vacancies, subject wise, medium wise, category wise, and gender wise, as determined by the commission based on the vacancies in the form of original PPO reported to the commissions by the concerned district inspector of schools AC. Next portion is important. At least 15 days before the publication of such advertisements. So therefore, whatever superannuations, creations, whatever happened, that is a creation of vacancy. The moment that vacancy happens, at least whatever the number of this creation or superannuation vacancies that happened, DI would informed so that an advertisement can be done under 8. And thereafter, lordship may kindly straightway come to 22(1). Then we will hold the selection, etc. And under 22(1), the commission shall hold counseling of the impanel candidates on the basis of their rank position as per the mode to be decided by the commission from time to time. And lordship may also see 21(3). Sorry, I made a mistake. I said 22(1), but I myself read 21. That was so gross bad mistake. Actually, I wanted to say 22(1), but I read a wrong rule. May I read the right rule?
22(1).
Yes, 22(1), because 22(1) will take to
3 as well.
21(3).
Yes.
So, but I do a reverse incorrectly. So, may I first read 22(1). The commission shall recommend the name of only, lordship may kindly mark the word, only one candidate against each vacancy as per his or her option choice exercise under sub rule 3 of rule 21. Now comes 21. There 21, lordship will see that 21(1) is the commission shall hold counseling of the impanel candidates on the basis of the rank position as per the mode to be decided by the commission from time to time. And then 3 candidates shall exercise their options to choose the vacancies during the counseling strictly as per the instructions. The reason, my lord, I have just placed these rules, that the moment there is a superannuations, nobody can say that I have to be accommodated there. That superannuations is nothing but a vacancy under the rule. The moment it is a vacancy under the rule, this is one of the components which is to be reported to the commission, which is an expert body for holding a selections from the entire pool. Once that is done, thereafter a candidate has a right, and then the vacancy can be filled up. Now this question came up. Now in the light of this rule, my lord, lordship may kindly take this, that very recent means it is on 13th of July itself, judgment 2026 SCC online SC 1313. First, my lord, the Honorable Supreme Court devoted one paragraph. In fact, this judgment, which takes care of the entire history of this Madrasa Commission Act, because lordships must be aware that once the legislation was brought in, our High Court declared it ultra virus. So there was a period when there was no working of the commissions. But ultimately, the Honorable Supreme Court set aside the single bench and the division bench of our High Court, and thereafter it started functioning. So all these judgments have been taken into considerations, including, in the meantime, if anyone has been appointed by the concerned madrasa, and thereafter a superannuation has happened, vacancy, whether he has a right, which is directly the case here. First, my lord, the Honorable Supreme Court were kind enough to record devoted a paragraph entirely on which are undisputed facts under paragraph 5.
Yes.
My lord, may I say the page, paragraph 5, it is at page number 3. Now, Lordship may kindly come to straightway. There are 5D, which is at page number 4.
Yes.
Close on the heels of such notification of MSC Act was enacted and enforced with effect from 22nd October 2008. It was modelled on the lines of the SSC Act. The MSC Act introduced the concept of selection for appointment on vacant sanctioned post of teachers and non-teaching staff in the recognized and aided madrasa through the aegis of an expert body, that is Madrasa Service Commission. Section 8 laid down the functions of the commission. Section 9 provided that the manner and scope of selection of persons for appointment to the post of teachers in the madrasa shall be such as is prescribed. Section 10, a non-obstante clause, ordained that the recommendations of the commission is mandatory. Section 11(1), that any appointment of a teacher made on or after the commencement of the MSC Act in violation thereof would have no effect in law. And Section 12 mandated the penalty and could visit the managing committee, the ad hoc committee, or the administrator, as the case may be, in case of refusal, failure, or delay in implementing the recommendations of the commission. These are the, if I can say, the very crux of the basic directions of the legislation itself, which is in the paragraph of the Honorable Supreme Court judgment under undisputed facts. Then Lordship may kindly take 5L. 5L is at page 6.
Yes.
Ultimately, this is 5L is referring also that part of the history where for some period this act was not working. Ultimately, a two-judge bench, speaking through Honorable U. Lolith, as the Chief Justice then was, upon considering several precedents in the field, including the Constitution Bench decisions of TMFI such and such, set aside the judgment and the order of the High Court under challenge, per its judgment and order dated such and such. Relevant passage, my lord, then paragraph 58 of the Honorable Supreme Court, that is quoted. The regime put in place by the state legislature thus ensured that the commission comprising of experts in the field would screen the talent all across the state, will adopt a fair selection procedure and select the best available talent purely on merit basis. And even while nominating, the interest of the minority institutions will also be given due weightage and taken care of. The statutory provisions thus seek to achieve excellence in education and also seek to promote the interest of the minority institutions. The provisions satisfy the taste of called out in the decisions of the TMFI. Well, next paragraph 59, that in our considered view, going by the principles laid down in the decisions of TMFI Foundation, the provisions concerned cannot therefore be said to be transgressing the right of the minority institutions. The selection of the teachers and their nominations by the Commission constituted under the provisions of the Commission Act 2008 would satisfy the national interest as well as the interest of the minority educational institutions, and the said provisions are not violative of rights of the minority educational institutions. Then Lordship may kindly come to paragraph 64, quoted 64, which is at page 7. My 64 is a quoted
Yes,
one.
yes.
In the end, we declare all nominations made by the commissions in pursuance of the provisions of the Commission Act 2008 to be valid and operative. However, if after the disposal of the matters by the High Court, any appointments are made by the madrasa concerned, such appointments of teachers shall be deemed to be valid for all purposes. But the commission shall hereafter be competent to select and nominate teachers to various madrasa in accordance with the provisions of the Commission Act 2008. Well, this was the recording of the earlier two-page judgment. Thereafter, kindly come to 28M, which is at page 25.
Yes.
Well, I shall be relying on the middle portion, but I am reading. It's a short para. Nonetheless, the advertisement dated 5th July 19 and the appointment letter 14 November 19 issued to the petitioner clearly stipulated that the appointment shall be subject to the final outcome of the civil appeal number such and such, which was pending before this court at the relevant time. Civil appeal number such and such having been allowed by this court, vide such and such, the vires of the MSC Act stood upheld. Appointments of teacher and non-teaching staff in the madrasa could therefore be made only in terms of the recommendations of the commissions and not otherwise. Thereafter, I'll take my lord paragraph 31D. It is at page 28.
Yes.
Well, at D, 31D, page 28. We find no merit in such prayer. First, the petitioner has not claimed the relief of regularizations in the writ petitions. Grant of relief beyond the prayer clauses, though normally impermissible, could be considered in exceptional cases. This does not qualify to be an exceptional case warranting departure from the settled rule of no prayer, no relief. Secondly, the question of the second point is relevant here. Secondly, the question of regularization in service does not arise in this case because of the nature of the breach that has occasioned. This court in such and such, even in the most recent decision in such and such, might have taken a liberal view, but such view have to be read as confined to its own facts rather than laying down law which is binding under Article 141 of the Constitutions. State of Karnataka in Umadevi and official liquidators Dayanand and larger bench decisions of this court. The ratio laid down therein has neither been doubted nor diluted by any bench of co-equal strength. The principle of stare decisis and Article 141 of the Constitution leaves us with no choice. Article 141 commands and the law declared in Umadevi and Dayanand binds all ratio, if any, laid down in the said decisions of benches of lesser strength as debatable, and we are not persuaded to follow the same. Well, thereafter, paragraph 42, which is at page 35.
Yes.
Consequently, we do hereby reject the claims of all the petitioners. Since the claims stand rejected, there is no question of the petitioners being entitled to any area of salary and allowances. Appointments not having been made either in accordance with the notifications 1 or notification 2, the state cannot be fastened with any liability to release payment. Orders passed on the writ petitions restraining the respondents from dislodging these petitioners from service and or directing payments of admissible salary and allowances stand vacated forthwith, because those petitioners, they were getting some interim order, all got vacated. Thereafter, my lord, 44 also, since the interim orders have been vacated, the vacant sanction post may now be filled up as per the recommendations of the commission. Now, in the light of that, Lordship may kindly take paragraph 6 of the writ petition. Well, I would say 5 and 6, both are very short paragraph. In paragraph 5, my lord, the petitioner states that since his appointment in the year 2011 as gateman of such and such, your petitioner has been continuously discharging his duties diligently and sincerely without any interruption in service and without any complaint or adverse remark being recorded. Now 6. Your petitioner most respectfully states that on 31st December 21, kindly mark the date, my lord, one permanent Group D employee of the madrasa, namely such and such, retired from service, and that with effect from 1st January 22, the said permanent Group D post has remained and lying vacant. Well, this is, if I now, based on this three things. Thing number one, I have placed the existing legislations, the relevant rules. Thing number two, the finality by the Honorable Supreme Court, clearly saying it has to be only by the commissions and only by the commissions. And there cannot be a regularizations, because his prayer to me is that regularize me. So it's a simplicitous saying, asking for a representation to be considered. But my lord, even leaving aside this matter, if I can just say that it's not about the law. Every human being fundamentally leads on hope. If there is a slightest amount of hope being possibility, I don't mind for any petition be considered. I would be the last person to say that objecting for the consideration of a simpliciter representations. But if Lordship finds that there is a gentleman who might be having a hope based on a representations, but the laws are so watertight, which has been declared by the Honorable Supreme Court, there, my lord, even on a point of, regardless of law, on a point of even humanity and sympathetic view also, more the person gets to know his fate rightly is better for his. It may not be good for him, but it could be, if there are choices between the good and the bad, someone would choose the good. But if the choices are between the bad and the lesser bad, knowing that I don't have a good case, therefore I should not have a hope, maybe more human. That's I feel. If there is a scope, hope is good. Little bit of nurturing is a hope good. But this is a case where he is fundamentally asking that there is a vacancy 2021. Now the Honorable Supreme Court is clearly holding, and no more interim order is there, that it has to go to the selection process and there has to be selections. So in that juncture, my lord, this prayer for a simplicity of representations doesn't stand. These are my respectful submissions.
Lord, the post that I am working on is not a sanction post. My lord, kindly, if your lordship may kindly consider the judgment passed by the Supreme Court, all the teachers were my lord holding my lord sanction post. My lord, here I stand as a person who was my lord engaged as a on a temporary basis, and I'm still working as a temporary basis. My lord, my stand is not equal to the stand of the my lord the petitioners before the Honorable Supreme Court. My lord, I have cited the superannuation of the Group D staff only as an example. My lord, even if I am not entitled to be regularized in that sanction post, I am, my lord, it is my humble submission, is that, my lord, I still have a right to be, my lord, considered in the light of, my lord, the Supreme Court judgments in Jago and the subsequent judgments. My lord, because, my lord, I have substantially worked, my lord, since 2011. And that, my lord, the superannuation of the Group D staff, my lord, has been cited only as an example that there is a sanctioned vacant post, I may be absorbed in that sanctioned vacant post, which cannot be done, my lord, in view of the, my lord, the Madrasa Service Commission's rules and regulation and the, my lord, judgment of the Honorable Supreme Court. But, my lord, being a temporary, a casual, my lord, staff, I still am entitled to be, my lord, considered for regularization in view of the Jaggo judgment and the subsequent judgment passed by the Honorable Supreme Court. May I place, my lord, the two judges?
Now, who will pay the monthly salary of
Well,
a
at
temporary
this-
staff?
Well, only one thing, this Jaggo judgment, which my learned friend is relying, in paragraph 31D, precisely that has been dealt with, because the judgment today I am placing, it is of 13th of July 2026.
31.
31D at page 28.
My lord, subject to correction, my lord, 31 was a case of an assistant teacher. Your lordship may kindly find
That has been considered.
starting. He is an assistant teacher, my lord. He was engaged as an assistant teacher.
It's not
But,
about, it's not
on a regular basis.
Specifies the posts
Yes.
for teacher as well as a non-teaching staff.
Non-teaching
and
staff.
The peon all are included in that post.
Yes, yes, my lord. But this was with regard to a sanctioned post, my lord. My post is not sanctioned. My lord, I am working as a temporary.
May I just may I make a small interjection? My learned friend is saying is not sanctions, but his prayer is just the opposite.
Regular.
Yes, he's asking to the sanction. Let's look at the prayer itself.
Regularization in service.
Yes, I've seen that. Because he says that my case is different. He's right. But that his rightness makes his case even worse. Different doesn't mean that my case is better. His case is different in a sense, even if he changes. For the time being, I assume that prayer is not there. And he is not even asking for for sanction. If he says that I'm not asking to be accommodated in a sanction post, then his case is worse. No one has a right, neither the state has a liability. Because unless the post is sanctioned, no one has a right in a service jurisprudence to say that I have to be accommodated. Then it would be worse. In any case, factually,
My lord, subject to, my lord, correction.
No.
My lord, senior, my lord, all these appointments in the, my lord, cited in the Supreme Court, this, my lord, Najma Khatun's case, all were, my lord, engaged on a regular basis. My lord, I am not engaged on a regular basis.
That's what I'm saying, it's words.
My lord, the Supreme Court says that since you have not come through the, my lord, the recommendation of the Service Commission, all the appointments are not regular. These are all illegal appointments, and hence, my lord, the order was passed. My case is, my lord, that I have been appointed in the initial basis, initially on a temporary basis, and I'm still a temporary employee. And my lord,
11 the tape in the year 2011 itself, 2008 the act has come. 2011, how can they appoint you?
my lord, in 2008, my lord, though the act had come, my lord, in the judgment itself, your lordship will find that no effect was given for a substantial period of time.
Anyway, that gap has been
And
given
after
in the order of Muhammad,
Jaggo, my lord,
judgment of Muhammad Rafiq. It says that since an order was passed by the High Court, if any appointment is given by the committee, that will carry forward.
probably, my lord, here in the
After
Supreme
that,
Court said,
after that, when the larger bench has decided the issue in Muhammad Rafiq, setting aside the order of the Honorable Division Bench, now the commission is the authority to. So if you say in 2021 there was a vacancy and that should be considered, then 2021 vacancy should fall before the commission by the District Inspector of Schools as per Rule 21.
Yes.
my lord, in 2011, when I was appointed, it was not, my lord, against a regular vacancy. It was solely on a temporary basis. A gateman was required. The madrasa, my lord, had the managing committee, my lord, decided to engage me. My lord, my prayer, my lord, my humble prayer is, my lord, let my prayer be considered in the light of Jaggo and the subsequent judgment passed by, my lord, the Supreme Court in Vinod Kumar. 8 I just kindly. That, my lord.
Which paragraph?
My lord, 5 onwards. My lord, may I read, my lord? Having heard the arguments of both the sides, this court believes that the essence of employment and the rights thereof cannot be merely determined by the initial terms of appointment when the actual course of employment has evolved significantly over time. the continuous service of the appellants in the capacities of regular employees performing duties indistinguishable from those in permanent posts, and their selection through a process that mirrors that of a regular recruitment constitute a substantive departure from the temporary and scheme-specific nature of their initial engagement. Moreover, the appellant's promotion process was conducted and overseen by the Departmental Promotion Committee, and their sustained service for more than 25 years without any indication of the temporary nature of their roles being reaffirmed. The duration of such temporary engagement being specified merits a reconsideration of their employment status. The application of the judgment in Uma Devi by the High Court does not fit squarely with the facts at hand. Given the specific circumstances under which the appellants were employed and have continued their service, the reliance on procedural formalities at the outset cannot be used to perpetually deny substantive rights that have accrued over a considerable period through continuous service. Their promotion was based on a specific notification for vacancies and a subsequent circular followed by a selection process involving written tests and interviews, which distinguishes their case from the appointments through backdoor entry as discussed in Uma Devi. The judgment in Uma Devi also distinguished between irregular and illegal appointments, underscoring the importance of considering certain appointments, even if were not made strictly in accordance with the prescribed rules and procedure, cannot be said to have been made illegally if they had followed the procedure of regular appointment. As such, conduct of written examination such and such. Well, then the Uma Devi judgment has been quoted. In the light of the reasons recorded above, this court finds in the appellant's argument and holds that their service condition as evolved over time warrants a classification from temporary to regular status. The failure to recognize the substantive nature of their roles and their continuous service akin to permanent employees comes counter to the principle of equity, fairness, and the intent behind the employment regulations.
Well, only one sentence. This precisely Jaggo in paragraph 31D. Kindly just one sentence where that is at page 28.
Yes.
Kindly take my lord 1, 2, 3, 4, 5, 6, 7, 8, 9. After 10 lines.
D.
Yes, after 10 lines. This is
Yes.
Jaggo confined to its own facts rather than laying down the law which is binding. So Jaggo is not Article 141. The latest Supreme Court is saying that. Jaggo has to be confined to its own facts.
I'm not getting that.
May I say, Lordship has got D.
D, yes.
D starts with we find.
Yes, this quote in Jaggo and yes.
Yes. This quote in Jaggo and even in the most, even after Jaggo, following Jaggo, there was Sukhendu, might have taken a liberal view, but such views have to be read as confined to its own facts rather than laying down law which is binding under Article 141. Meaning thereby, Jaggo have been understood by the latest Supreme Court to be not an 141, and it is confined to Jaggo's own factual scenario. These are my respectful submissions.
And my lord, I say that, my lord, I am placed, my lord, similar to my lord the petitioners before the Honorable Supreme Court in the case of Jaggo, because I am also, my lord, a temporary casual employee.
Okay. कल के ऑर्डर से दिया था और Mr. Devashish Banerjee, learned advocate for the petitioner, who concludes his argument. Mr. Pratik Dhar, learned senior advocate appearing for Madras Service Commission, also concludes his argument. Release this matter tomorrow under orders. कल के order. Tomorrow for orders.
Yes, I am deeply obliged.
For orders.
Just a minute. এই সুরিত বাবু আপলোড হয়েছে কিনা অমিতাভ বাবু চেক করে ইয়েস
Why did I prefer the petitioner led by Mr. Jayanta Kumar Mitra? Today, Mr. Mitra is feeling uneasy and high sugar could not come to court today. I'm praying adjournment today and praying, my lords, if permitted, feast
Mr.
on.
Gupta has come. Mr. Gupta.
After we have been informed.
I mean, we informed that Mr. Mitra is not keeping well, so that is why.
In the morning we have been.
My lord, kindly fix the matter on next Wednesday, my lord.
Just find out. Mr. Gupta is well now.
No, he is well, but in the morning Mr. Mitra called him, informing that he is not keeping well. So that's why Mr. Gupta has not come to.
Today morning itself.
Mr. Gupta, my Lata senior, informed me in the morning. He won't be coming.
কবে বলো ইত্তগজ দেখে না ওটা আবার আছে সেই মেডিকেলের ওটা আছে
Wednesday.
কি করবো
Wednesday. সেটাই বলে সেটাই
Anytime.
5th August শুরু 5th August
5th August.
Only Mr. Mitra will give some.
Accommodation is sought for on behalf of Mr. Jayanto Kumar Mitra, learned senior advocate appearing for the petitioners. List this matter on 5th August at 2 p.m. 5th August 2026 at 2 p.m.
My lord, on the last occasion, there was a direction on the West Bengal Nursing Council to submit a report.
Yes, my lord.
And my lord, may a copy be also be served upon us.
আমার কপিটা দেখেন
What was in the order and what is in the report? She has indicated that there was an inquiry at the behest of your client. I have indicated that what was the outcome of that inquiry.
Page 9091, my lord, of my
Para
petition.
4, accordingly, in view of the above, respond number 3, West Bengal Nursing Council directed to submit report of the inquiry undertaken by it pursuant to letter dated such and such of the principal. But you have not stated anything, just one paragraph that all those attendants are lying with the college authority.
Yes, my lord.
Then what was your inquiry? Did you peruse the attendance register and come to a finding that such is the shortage? Where is that report?
After satisfying the.
Sir, where is that report of inquiry? Now you visited the college, you have made an inquiry pursuant to a letter of the principal. That has not been annexed. Nothing has been stated of that inquiry.
My lord, the final year mark sheet has already been handed over to the college authority. And the college authority allowed the
Sir,
petitioner to appear in the
I
examination.
have made it clear
After
that there
going
was an
through
inquiry at the instance of the nursing council. Where is that inquiry report? I have stated in the last order.
During pendency of this writ petition, the petitioner will not file another complaint before the police authority. On the basis of that police authority, all the data will not lie in custody of the police authority.
It says that college.
The police came.
No, you are saying it's with police.
No,
The person who is filing the report, he says that it is with the
That
college.
report, I'm not interfering about this. Whatever the inquiry.
No, that is separate issue. We'll decide on this.
Data is concerned. will not-
First of all, this report is incomplete, sir.
My
If
lord,
you have to comply the last order of 8 July 2026, then you have to state what was in the inquiry report, annexing the inquiry report. I want to see that what was the inquiry conducted by you.
The dispute is totally between the college authority and the writ petitioner. After satisfying all the formalities, the college authority sent and allowed the
Will
name
the
of the
council allow the court to come to a finding? Will they assist the court in coming to a
no such
finding?
information has been available to the council.
So that's why I've asked you file a report. What was the inquiry? Whether it is a dispute between the petitioner or the college, we are not concerned right now at this stage. We are concerned to find out what is the allegations made by the petitioner, whether it is sustainable or not. That's why I asked you file your inquiry report. What was in the inquiry?
Unless the candidate is allowed by the college authority, the council does not allow.
My lord is suggesting that page
The
90.
report in the form of affidavit filed by the nursing respondent number 3 West Bengal Nursing Council is taken on record, copy served. It is found that the report has not been filed in consonance with the order direction issued VD order dated 8 July 2026. West Bengal Nursing Council is respondent number 3 is directed to furnish report strictly in compliance to order dated 8 July 2026.
These document lies with the college authority, and these documents, the attendance is also been annexed with the writ petition. How the nursing council will answer that the attendance is sufficient or not? The college authority allowed the writ petitioner to appear in the examination.
Fine. Nothing is with you.
No.
Then you held an inquiry. That is no. Is the answer to whether any inquiry was held, it is yes or no?
Not the inquiry.
Is it yes or no? Was there any inquiry?
To the attendance, no inquiry has been
My
held.
lord, page 90. It's part of my record. It is on the letterhead of the West.
Find out why you are filing all these reports.
This is not the domain of the nursing council. Kindly note my argument. Upon satisfying with the name sent
Sir,
by the college.
I will not get into all this. My direction was that there was an inquiry by the council. There was
the inquiry held whether the candidate
of the principal of the college.
Is the
Sir, please try to understand. There was a direction that what was in the inquiry. You have not stated anything regarding the inquiry or inquiry report. Either you say that there was no inquiry, so you're out of this. If you say that there is inquiry, place that inquiry report and to find out what was the attendance. As simple as that. You say that there was no inquiry. Though principal made an application, but there was no inquiry with regard to Sriyosi. Or if there was an inquiry, what was the inquiry report? That is what I have asked for. Did I say that you assess the attendance is correct or not?
Kindly realize that after allowing a candidate for a particular examination by the college authority, subsequently the college authority cannot raise this issue.
Try to understand. I have not gone into the merits. She has indicated that there was a complaint
and an
inquiry was undertaken by the authority. Council.
Yes.
I have asked the
and
council.
after inquiry, the council
file a
felt
report
that the final year
regard
mark
to
sheet
the
has
inquiry.
already been handed over to the
Chalo.
college authority.
Huh? So you are not filing any exception to the report?
No inquiry on this particular issue. Kindly note it down.
Why? Did you state that? Did you state in your report that there was no inquiry? Did you state in your report that there is no inquiry?
The candidate is allowed for the examination and his mark sheet has been handed
No,
over.
have you stated in your report that you did not conduct any inquiry?
No, I have stated in my report that the attendance details has been lying with the college authority.
But বলো তো report strictly in terms of order dated 8 July 2026 annexing the inquiry report. We annex the inquiry report. Let us find out. Correct. Sure. After 15 days of. All right. Now, copy the 53.
My lord, I am appearing in behalf of petitioner, my lord. My lord, Mr. Devajyoti Basu is leading us in this matter.
For the state euros.
My lord,
I think he has muted himself.
Well,
Mr.
I'm sorry. Good.
Yes.
Now, my lord, am I audible now?
Yes.
Now, my lord, pursuant to my lord's last direction, my lord, where lordship directed us, my lord, to serve again.
Yes.
Although, my lord, on previous occasions, my lord, pleadings were all complete, and my lord, all parties appeared. Now, my lord, subsequently, the private respondent, although filed his pleading, but thereafter choose not to appear. But lordship directed, my lord, us to serve again. I believe, my lord, private respondent has appeared today.
You are not signed for the private.
Yes.
Now, my lord, so far the service to the state, my lord, we have done so. My junior is there, my lord. He will file the affidavit of service.
Okay. Did state file any report?
No. The state has already filed his opposition. We used our reply. This is only, my lord, a very short question, my lord. The cancellation of our mutation that is under challenge. Now, pursuant to your lordship last directions, my lord, we have done service again.
Okay. Yes, you place your case.
My lord, may then kindly keep it, my lord, next week, my lord, for hearing, because today, my lord, is fixed for filing affidavit of service. My lord, we can proceed, but it may not be
Affidavit
a
of service filed on behalf of the petitioner is taken on record. Mr. Devajyoti Basul and a senior advocate appearing for the petitioner seeks for fixing the date for final hearing. 3 সপ্তাহ পরে একটা জায়গা দাও দেখে নিয়ে আসো copy you have got Mr. Singh, you have received the copy.
My lord, may it be on 5th, my lord,
Not
next
on
Wednesday.
No.
Very
Some
well,
other day.
according to my lord's convenience.
Yes. 19th August.
19th August.
Yes.
Deeply obliged. Grateful.
Lord, in item number 54, Lordship, I have just been briefed on behalf of the Kolkata Metropolitan Development Authority.
Yes, respond number 1 and 2.
Yes, Lordship, will it be my lord's kind pleasure to take it up any day next week, subject to my lord's convenience?
You have filed your opposition.
Lord, I just received brief yesterday evening.
He has filed.
On earlier occasion, the matter was.
No, KMDA has filed its opposition.
Yes.
When? What is the date? Affidavit in reply is also there.
Reply has also.
Yes, it has filed.
Lordship, it has been filed.
15th March.
সত্যজিৎটা ছিল আগে এখন তো প্যানেল চেঞ্জ হয়েছে না সেটা জানি না সেটা তাহলে সাহেবকে বলে তুমি করিয়ে নাও
On the earlier occasion, we tried to serve upon the state also. State is also a party here. But they refuse service. I don't know today.
Well, there has also been a change in the state panel. I don't know.
Copy দিতে গেছেন কেউ নেই না। আপনি নোট করে দিন না। হ্যাঁ আমি নিয়ে নিচ্ছি তাহলে দিয়ে দাও। Kindly serve the copy.
Oh, you have served in the office?
We have tried to serve. Our clerk went, but Lordship, he is absent.
An advocate, you have the copy, then hand it over. Then the advocate for the petitioner is directed to hand over a copy of the writ petition along with its annextions and other pleadings. Other pleadings also you give it?
Sir, Lordship, by tomorrow itself.
একটা কাজ করুন এরকম লিখে দিন, the learned advocate appearing for the petitioner undertakes to serve copy of the writ petitions and other pleadings upon the learned advocate for the state by tomorrow.
My lord, kindly by presence be regularized, your lordship.
None appears on behalf of the state. Opore. Mr. Brajendra Pratap Singh, learned advocate who usually appears on behalf of the state, is requested to appear in this matter. Let the appointment of Mr. Singh, learned advocate, be regularized by the concerned authority. So, learned advocate. Accommodation is sought for on behalf of KMDA, respond numbers 1 and 2. Follow? পরের দিকে রাখো, এখন দেখবে তো ক্লিনিং সিন পড়ে আসবে। 26th.
I'm grateful.
But I am for the petition. I am for the state. Well, I will first come to the petition. There was a petition which was filed. There was a report which was filed by the state. My lord, kindly come to the prayer in the writ petition, my lord. Prayer lordship will find it in page number 8 of the petition. My lord, here the first prayer was, read in the nature of mandamus commanding the respondents to pay compensation to your petitioners for the said land immediately. B. Read in the nature of certiorari directing the respondents to produce the records of the case so that on perusal of such records, the order dated 19/1/2023 may be quashed and or set aside, or conscionable justice may be done between the parties. My lord, now I'll take your lordship to the order dated 19/1/2023. Well, this 19/1/2023 order would be found from the page number 34. Well, let's see, lordship, the first kindly come to order dated 21/10/2022, seen the order of the Honorable Justice Shubhra Ghosh dated 16/9/2022 in connection with WPA number 16285 of 2022 with a direction to the second respondent to consider and dispose of the representation of the petitioners after affording reasonable opportunity of hearing to all the affected parties, including the petitioners, in accordance with law. Notices are issued to all interested parties fixing a date of hearing on 3rd November 2022 at 12:30 p.m. Next, notices issued to all interested parties, service return filed and kept on record. Then 3/11/2022, the case is put up for hearing. Petitioners are present, represented by their learned advocate, such and such, on behalf of the BLLRO. Horinghata Nodia is also present. Petitioner's advocate perused from Form 13A of LA case number 1 BRP 7980. The payment status of acquired 0.77 acre of land in plot number 232 RS in Mouja, Aishpur, jail number 9. After hearing all the parties, PWD Roads, Kullani Division and BLLRO Horingata are directed to submit their views and report the comprehensive manner. Then 23rd December 2022, received a letter from Executive Engineer Nodia Highway Division, number 2 PW Roads, Directorate, but no report is received from BLLRO Horingata till date. However, to avoid inordinate delay, a date of hearing is fixed on 16/1/2023. Then, Lordship, kindly come to the impugned order, which I am seeking the quashing of. Case record is taken up for hearing and
Prayer
passing necessary
of
order.
the order in prayer is wrong.
My lord?
In prayer, you have stated 19th January 23. It will be 16th
Yes,
January.
60. It should be 16th, my lord.
Yes.
Yes. The case record is taken up for hearing and passing necessary order. Uttam Das, on behalf of the petitioner, is present by filing Hazira. Assistant Engineer PWD Roads is also present. Fact of the case in brief is that in WPA number 16285 of 2022, the Honorable Justice Shubhra Ghosh, Wide solemn order dated 16/9/2022 passed the following order. I'm skipping it. In his representation, writ petitioner stated that plot number 140 of Mouja Ayeshpur, district Nodia, with an area of 77 decimal, has been acquired, but no compensation has not been given of such land. Lordship, kindly note that plot number 140, Mouja Ayeshpur, district Nodia, total area of land under acquisition was 77 decimal. During hearing, I have heard the petitioner and the state respondents also peruse the documents submitted by them. On perusal of the office record, it appears that 36 decimal of land in plot number 140 of Mouja Ayeshpur, jail number 9, police station Horinghata, was acquired in LA case number 87 of 2011 for road transport and highway department. But afterwards, on careful examination of office records, it appears the plot in question, that is plot number 140, corresponding CSRS plot number 232 with an area 77 decimal of Mouja Ayeshpur, district Nodia, has previously been acquired. Wide LA case number 1 BRP 7980, and the compensation has been given. Lordship, this year is very important, 7980, and compensation has been given to the awardees. On perusal, it also appears that the plot in question is recorded in favor of পরিবহন ও জাতীয় সড়ক মন্ত্রণালয়ের পক্ষে ভারতের রাষ্ট্রপতি সাং রাষ্ট্রপতি ভবন নয়াদিল্লি ওয়াইড খতিয়ান নাম্বার 12701420, as compensation had previously been given to the concerned awardees in respect of the plot question of giving further compensation in respect of same plot does not arise. As such, having regard to the facts and circumstances and on examination of materials of record, I do not find any merit in the representation made by the petitioner. Let the plain copy. So, Lordship, there was the case. Admittedly, in 7980, they said that they have already given the compensation to the awardees, and since the compensation has been paid by virtue of the LA case number 1 BRP 7980, no further compensation can be paid to the original owner or claimant, that is the petitioner, who is claiming the compensation now. That is the point which is to be decided, and we prefer this writ petition, my lord. My lord, now, Lordship, kindly come to few of my pleadings from the petition which would be relevant, my lord. Then I'll come to the. My lord, kindly come to paragraph number 3. Petitioner's predecessor interest are the owners of the land, being Dag number 140, Khotiyan number 271, jail number 9, measuring 77 chotak land, Mouja Ayeshpur, district Nodia. So, my lord, petitioner's predecessor was the owner of that land, 77 decimal of land of Khotiyan number 271, Dag number 140. Your petitioner states that Kalipodo Das died on 12/6/1967 and Pachu Das died on 2/12/1972. My lord, before this, I want to refer to annexure P1 once. My lord, kindly come to P1, my lord. P1 is the documents Giribala Devi, Lordship, will find. Then, Lordship, kindly come to P2, page 13. Kalipodo Das died in the year 1967. Petitioner's predecessor in interest died in 1967. This is the record issued by Chaduria Shoshan Ghat, Shimurali Nodia, dated issued in 2013. Kalipodo Das, Shamin Nam, such and such. Then next page, Pachu Das died in 1972. Then 7780, they were the petitioner's predecessor in interest. One died in 1972, one in 1967. Now, Lordship, what has happened? kindly turn to the pleadings once. In paragraph number 5, the government of West Bengal made a notification by the additional district magistrate land acquisition district Nodia dated 31/8/2010 that they have acquired the land of your petitioner's predecessor for or road transport and highway department. But kindly come to P3. This is the notification. When we came to learn, P3 is in page 15. Page 15, my lord, would find that it's the notification of 2010, and lordship will find from page number 17. Page number 17 from top
140.
7, 8, 9, 10, 11, 12. Lordship will find that here it is Pachu Das. Lordship has found Pachu Das name.
Where is that? 11, column 11.
Column number, Lordship, the row, 11th row, my lord.
7, 8, 9, 10, 11. ELR 140.
11, 12, 13th row.
ELR 140.
140.
Yes, Pachu Das.
Pachu Das. Lordship has found.
Yes.
Now, Lordship, this was issued in the name of Pachu Das. Who died, my lord, I have shown from the record. My lord, Pachu Das died in 1972 and his body was cremated in Chaduria Shoshan. Page 14, my lord. Now, kindly come to paragraph number 6 of the writ petition. As per notification dated 31/8/2020, the authority concerned acquired the said land of your petitioners, but till today the authority concerned have not paid any compensation for the said land to the petitioners. Made representation. I am not on that, my lord. Then paragraph 9, the petitioner filed the writ petition. Thereafter, my lord, kindly come to paragraph number 11. Your petitioner state the authority concerned did not consider the comprehensive representation within the time specified in the order passed by the Honorable Justice Ghosh. Do not want to proceed in the matter. The competent authority has passed the order on 19/1, that is that order which I have referred to, my lord. 16/1/23. Is Xerox copy. And 17 is very important, my lord. Petitioner states that under section 11 of the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement, compensation, rehabilitation and resettlement and development plan, rules 2015, government has a right to pass award in the instant case, but the authority concerned has not paid the compensation in the instant case, which is illegal and not maintainable in the eye of law. Now, lordship, hence the writ petition, lordship. The firstly, writ petition was filed and the state was directed to file a report. And lordship, kindly come to the report dated 18th May 2023, filed by one Joyanto Kumar Bosak.
Status report by the stipulated authority.
Well, then this is the report which is important, my lordship. All reports are important. This current status report, my lord. কিছু নতুন কিছু আছে কমপ্রিহেনসিভ রিপোর্ট
Obviously, সেটা already
আপনার কাছে
exist check number আপনি রিলিজ করেছেন তার কিছু
তোমার দেখুন Sorry, may I take? But kindly come to in this report filed by the additional land acquisition officer. Sri Joyanto Kumar Bosak is the land acquisition officer. Lordship, kindly come to this report. Page 3. Brief
Supplementary report has been filed also.
Yes, yes. Both are important, my lord, to read it. The petitioners filed the writ petition being number such and such. In the said writ petition, it is stated the petitioners that the authority concerned has acquired the land of the petitioners but has not paid any compensation till date, which is absolutely false and fabricated. These petitioners previously filed one writ petition being number 16285 of 2022, and the Honorable Justice Shubhra Ghosh was pleased to dispose the writ petition with liberty to the petitioners to submit a comprehensive representation ventilating their grievances before second respondent, and second respondent is directed to consider and dispose of the representation after affording reasonable opportunity of hearing to all the affected parties, including the petitioners, in accordance with law. And on the basis of that order, one comprehensive representation was submitted. And hence, on perusal of the office record regarding LA case number 1 BRP 7980, in respect of plot number CS or RS 232 corresponding to LR, plot number 140 measuring an area of 77 decimal of 9 number Aishpur Mouza under police station Horingata, it transpires that Kalipodo Das and Pachu Das, both sons of Nolini Das, were recorded in the RS ROR being number 40 in equal shares. Pachu Das died unmarried, and so his share was devolved upon Kalipodo Das, and Kalipodo Das got 16 anna share measuring an area of 77 decimal of land. RS recorded tenant Kalipodo Das transferred his entire share in favor of Kalipodo Ghosh, son of Biharilal Ghosh, by virtue of a registered sale deed being number 3283 dated 8/3/1960. And the name and possession of Kalipodo Ghosh was correctly reflected in the field inquiry report. Report is annexed. Subsequently, compensation was given to the awardee Kalipodo Ghosh, son of Biharilal Ghosh, in respect of the suit plot of the land, following all procedures as per provision of law. On perusal of LR ROR concerned, it also transpires that the plot of land in question has already been recorded in favor of পরিবহন ও জাতীয় সড়ক মন্ত্রণালয়ের পক্ষে ভারতের রাষ্ট্রপতি, wide LR খতিয়ান number 1270 and 1420, as compensation has previously been given on self-same plot of acquired land to the concerned awardee. Question of giving further compensation does not arise. Well, this was the report. Then Lordship kindly come to the document annexed to this report, where Lordship will find the name of Kalipodo Ghosh, which will feature in the left-hand side. Page number, internal page number 5 of the said report. 5. Lordship will find Kalipodo Ghosh will be found. Lordship will find Kalipodo Das 1, 2, 3, 4, 5, 6th column, my lord. Khotian 40. Rayat Kalipodo Das, Pachu Das. There is a it is striked out. Nilmoni Das. Then Lordship has found.
Yes.
So in record, it was recorded in there Kalipodo Das. Thereafter, next page, my lord.
No, both
Here
name
also,
of name of both the persons are there.
both the persons, Kalipodo Das and Pachu Das. My lord, this is the ROR based on which they have concluded. Now, Lordship, kindly compare page number 3. They said that the last paragraph, the Aishpur Mouza Horingate, it transpires that Kalipodo Das and Pachu Das, both sons of Nolini Das. Now, Lordship, kindly come to the report, page 3. Both sons of Nolini Das were recorded in the RS ROR being 40 in equal shares. Pachu Das died unmarried, and so his share was devolved upon Kalipodo Das. And Kalipodo Das got 16 anna shares measuring an area 77 decimal of land. RS recorded tenant Kalipodo Das transferred his entire share in favor of Kalipodo Ghosh, and registered sale deed being number such and such in the name of Kalipodo Ghosh, correctly reflected. Subsequently, the compensation was given to the awardee Kalipodo Ghosh. So, on the basis of a registered deed, they have given the compensation. Lordship, kindly note the deed number, that is 3283. This I will come to this later. 3283 dated 8/3/1960. Now, Lordship, After that, there was a direction upon them to file. Upon perusal of this, your lordship was pleased to direct them to file another report. That is the report in form of the affidavit on behalf of respondent 3. The same person has given. But kindly come to. No, sorry. No, I took the exception, Mal. I'm very sorry, Mal. Exception has been filed to this report. Exception by Sri Dhananjay Das, the petitioner. Lordship is found. But in the exception, I will be reading only paragraph number 5. With regard to the statements made in the report of that Kalipodo Das has transferred the said land in favor of Kalipodo Ghosh by virtue of a registered sale deed, which is absolutely false, and in the said deed no signature have been made in the sale deed, which will be cleared from the said sale deed itself. And 6, with regard to the statement made in the report, I also state that earlier the authority concerned also tried to deprive your petitioner by registered deed in the name of Robindranath Das in the said plot of land, and stop payment order was also made. Now, Lordship, kindly come to the documents. I've given the deed, Lordship. That's why I requested Lordship to mark this number 3283. The deed number which is mentioned in the earlier report. Page number 4. But kindly come to this deed. In the supplementary affidavit, my lord, I have given a clear copy of the deed, my lord. If you lordship kindly take one supplementary affidavit has been filed, just to produce the copy of the deed, my lord. Better type copy is given. Lord, you got the deed. Now, this translated version I have given. My lord, sale deed number such and such. Police Horingata, such and such, Riyarilal Ghosh, residing village Aishpur. I have purchased without any coercion on the intention to myself and possession of Kalipodo Das, Sri Pachu Odhikar, Panchanan Odhikari, on this time for the household expenses and other reasons, and the requirement of the cash fund, I decided to sell my property. After taking information, you ever agreed to purchase the property which is described in the schedule herein for rupees 400. Now here, if your lordship kindly turn to the earlier deed 3283, lordship will find this is a deed of 1960. What this deed, Mandel? They are saying that 1960s deed, they said that schedule of the property is given and this was transferred to Kalipodo Das, but there is no signature I found. What I found on contrary, man, here in the everything is written here, there is no signature. In the left side, my lord, the signature should be found. Your lordship will find sub-register Chagda. Thereafter, one Kalipodo Das. Lordship will find, as your lordship found.
Yes.
Executants Kalipodo Das.
Page number 20.
Page number 6, my lord. Supplementary affidavit. In the executants and claimants, Kalipodo Das and Panchanan Odhikari. Then lordship kindly come to
This cancellation of deed has been filed. There is any prayer for cancellation of deed before the civil court?
No, my lord. We came to know here only.
But
well, then kindly come.
On the last occasion when this matter was taken up, I got a number. I gave you that this number is appearing. A civil suit number was given. and I directed you just confirm from your client what is this civil suit about.
My lord, title suit we have not
There are
filed, my lord.
two things. In 1960, both Pachu and Kalipodo were alive.
Yes.
So Kalipodo Das was not in a position, even if it is taken for granted that he signed. Then also he had the half share, not the full share. Correct. Now, the report which has been filed, it says that Pachu's share has devolved upon Kalipodo,
My lord.
which is practically impossible because Pachu died later on.
Yes.
Correct.
So therefore, my lord, this portion, already there is a portion which we are in a position to say that
Petitioners are deriving their title from whom?
Pachu as well as
Kalipodo.
Kalipodo. Pachu died, my lord, later to Kalipodo's death. Kalipodo died in 1967. Pachu died subsequently in 1972.
Why this was not brought to the notice of the competent authority at the time when the assessment was done?
My lord, this was not. We had no idea, my lord, at that point of the time. After publication of that advertisement, which I have shown in 2020, that advertisement, we found our name, which is recorded Kalipodo and Pachu. There was no recording in the name of Kalipodo Ghosh. Now Kalipodo Ghosh now appears and go and say that I have purchased the land from Pachu. And this deed is mentioned there. So from that report filed by the state. And now this deed says, my lord, this Pachu and Kalipodo, both names are written there on the left hand side. Now, my lord, kindly come to in my kindly come to paragraph number 2 of my supplementary affidavit, my lord. I've taken this point that your petitioner filed the above mentioned writ petition before the Honorable Court on 6/2/2023, but unfortunately, some important facts along with annexures which are stated by the respondents in their exception in the form of an affidavit are not legible as per the order dated 4/11/2024 passed by the Honorable Justice Bibas Patnaik. Therefore, the Honorable Justice granted the petitioner's leave to file the supplementary affidavit. The petitioner states as per the report in the form of affidavit filed by the respondent number 3, wherein it is mentioned that Kalipodo Das transferred his entire share in favor of Kalipodo Ghosh, which is false. By virtue of the registered sale deed being number 3283 of 1960 dated 8/3/1960, before filing the same report at the time of hearing before the learned district magistrate Nodia, that provided us another deed number 3703 of 1974 that we have annexed in this supplementary, wherein it is stated that the said property was transferred to one Robindranath Das and Subir Das residing in village Birohi by Kalipodo Das and Pachu Das, son of Bonomali Das. It is to note that above two mentioned deeds are confusing in nature because the same plot of land was transferred to two different persons by two separate deeds. The deed number 3703 of 1974 was registered on 27/6/1974 by Kalipodo Das and Pachu Das, but Kalipodo Das died on 12/6/1967 and Pachu Das died on 2/12/1972. It is further stated that documents showing that Kalipodo Das and Pachu Das were cremated in cemetery on 12/6/1967 and 2/12/1972 respectively. That petitioner states, therefore, as per the report in the form of affidavit, it can be observed that Kalipodo Das and Pachu Das during his lifetime had transferred the disputed plot of land to Kalipodo Ghosh by a registered sale deed by deed number 3283. However, the petitioner begs to draw the attention of the fact that when the said plot of land was acquired by the state, it was Robindranath Das who was allotted the acquisition award of rupees 39,94,598 as is evident from CC voucher, which is annexed in the exception. Now, Lordship, kindly come to the deed number 3282. After that,
Next, Mr. Chatterjee, we stop here.
Well,
The report in connection with status report filed by Special Land Acquisition Officer. I gave you that number of the title suit that was appearing, not finding that from the record right now. That there was a title suit that was pending, whether the deed has been cancelled by the authority, by the civil court or not.
I will find out.
Yes. From the reports of the state, I suppose there was a document, there was an endorsement of a title suit.
But I will check and come back.
Copy has been given to you, status report? Copy you have given?
No, I have not.
Is taken on record.
Only 2 copy we have received from a bike.
A status report filed by Special Land Acquisition Officer Nodia. কবে বল ডেট বলো ফাঁকা দেখি দেখো দিন 10-15 বাজে এটা অ্যাসাইন্ড ওয়েডনেসডে বলে দাও 12th অগস্ট থেকে ফাঁকা দেখে এটাকে উপর দিকে রাখবে
12th August, man. I'll go through this report, my comprehensive report. I'll prepare my written notes of argument so that.
And also take that instruction. What is
I
the...
will.
Yes.
I will.
কোনটা একটা পিকচার আছে না 3টের সময় 3টের সময় কোনটা আছে
92. My lord, I'm praying for short passover.
92
92. This পুরো আসছে this short passover. Passover, short passover. State, short passover. না, short passover.
Interview is complete. Interview.
Interview is not yet complete. 11, 12 I am told complete. 9, 10 is not yet complete.
Where is the state?
My lord, I'm praying for short passover, my lord.
Passover from 3:30. There are other matters also.
My lord, short.
Who will argue?
Sahasrangshu Bhattacharya. It's on his legs, my lord.
Ram.
Larnet AGP.
When is the date fixed for interview?
Well, not yet fixed.
You join in the primary school right now.
Well, the difficulty I will explain. I will argue this matter. Now, suppose I join your losses. Suppose I join. Tomorrow I get there selected and appointed. Again, I have to go. See the precarious situation.
If the notification is not there and as per the dint of the order of the Honorable Supreme Court, if you are entitled to join, then
if I'm correct, state will ask for extension. Going to ask for extension because it's the state fault.
31st August is the last date.
Last date. If they do not complete it, where should I go? Then again I will go to primary. I'm selected. Already I'm empaneled. Interview is going on. If I'm selected, I will go again. And so far the explanation given by the council, I will explain to your lawsuit. Council is saying there are shortage of teachers. They need me. Have they completed any selection process? 25 selection process is also stalled by the board. So how could they say this, all these? Luckily, I am getting an appointment,
how long this
back to my original post.
Even if that date is extended for the sake of argument is considered, then also how far you will wait?
But until it is concluded, logically concluded, that's my submission. I will argue that. Because I am not at fault. No fault can be attributed to me.
Yes.
And they used to extend it because of these reasons. And those documents are annexed also. Will take little time. I will take your losses to all the documents. Even the last time commissioner extended it, then on the advice of the probably earlier dispensation, they kept in abeyance. And then your losses extended the order again.
So now we are at the end of July. 31st August is the last. When the matter will be taken up before the Honorable Supreme Court?
My lord, unless they take out an application or any of the from our side also, from either side that might be, then your losses on urgent basis, the Supreme Court will hear it. Because there is nothing pending except that matter. That this come to a logical conclusion.
End of August, this has been given already.
Considering that,
accommodation is sought for on behalf of the state. তার আগে দিয়ে দাও অগস্টের মিডল অগস্ট একবার দেখি mid of August.
Well, logically keep it on 3rd week of August. That would be proper. In the meantime,
19th দেখো তো Mr. Prasad is appearing for?
For the council.
I'm for the council.
You have filed your opposition?
Yes, Father. Dating is completed.
19th August 3 p.m.
I'm getting.
19.
For the petition,
They have modified that. Modification order has been made.
in this matter?
Yes.
No. This, in a nutshell, my lord, this is a property situated on NH. And for the expansion of NH, National Highway, my property was acquired. Initially, a compensation amount of 87 lakhs odd amount has been paid. I went and said, objected that 87 lakhs won't be the appropriate compensation because as per the building plan, my area of square meter or in square foot is much more larger than what the authority has measured. Then I came before this court by filing this instant writ petition, asking them to pay the, then thereafter they revisited their measurement and they found out themselves, yes, another 38 lakhs odd amount would be payable against my account. Then, my lord, I came before this court and filed this instant writ petition saying that that 38 lakh odd amount which they have not paid, let them pay that compensation. Then I can take it further if I am unhappy or not satisfied by saying that all the components mentioned under compensation, that loss of business and other parts, they have not paid. I could not do it because they demolished it, the entire building, and they have come up with several reports, one by NH, another one by state respondents, and thereafter my lord was pleased to direct them to go and remeasure it again, because the entire measurement had taken place behind my back during the COVID period without giving any notice. They have measured it and they have calculated the amount, that 87 lakh odd amount, the initial amount. And thereafter they had measured as per my lord's order. And now they are saying, no, that 38 lakh odd amount, which we decided later on, we revised it, that was wrong.
you are only entitled to get that 87 lakh and odd amount. So, my lord, I would like to use the exception to the last report filed by the state. Oh, I'm sorry, my lord, NH. Perhaps NH last occasion, my lord, kindly.
Yes, they have filed a report.
Yes, my lord, I would like to use the exception towards that particular report. All previous reports we had filed the exceptions.
Okay. Mr. Supratim Dhar, learned senior advocate appearing for the petitioner, seeks to find exception to the report of the NHAI dated
order
17 January 2025.
Yes.
Let such exception be filed within a period of 2 weeks. As a respondent, NHAI is not represented. State is not the answering.
State is also, because the under NH Act, the competent authority
is the state.
Is the ADM, concerned ADM, LA.
They have filed their report.
They have filed their report.
Just to give a copy of the writ petition and other pleadings to the learned advocate for the state.
I will do that.
Learned advocate for the petitioner is directed to serve a copy of the writ petitions and other pleadings to the learned advocate for the state by the returnable date. Do Shaptapod.
Our appearance may be regularized, my lord. Otherwise,
Mr. So-and-so learned advocate, who usually appears on behalf of the state, is requested to appear in this matter. The appearance of Mr. So-and-so be regularized by the concerned authority. Therefore, a learned advocate for the petition directed to serve.
I'm deeply.
Yes.
my lord, 57 and 58. Both.
Lord 57, Lord, I appear for the petitioner in this matter. 57, I appear for the petitioner in this matter. Now, Lord, on the last occasion, your lordship had directed them to file a proper application for substitution. Your lordship will recall, my lord, when Jyotsna Bhattacharya was a petitioner, has passed away.
Oh, yeah. Which is this
The
application?
application has been served upon me, advance.
My lord, here.
Which is this application? It is appearing.
Application not for substitution. I have been served with an advanced copy which was not filed. Your lordship had directed by an earlier order to file the copy, file the application in the department.
Okay. Which is the CAN which is the CAN application for substitution?
I have filed substitutional petitioner number 1 already been died. Petition number 2, they are my lord. My lord,
So,
I am praying for substitute. The petition number 2 is would be 1.
petition number 2 will proceed further with the writ petition. He or she is the only legal heir of 1.
From 1.
1.
From 1.
Where is that application?
I have filed
CAN number.
CAN number 1.
CAN 2.
CAN 2. CAN 2 to.
CAN 2 of 2026 देखो तो file टे.
CAN 2 has been filed by me.
CAN
2, Lord, I used the application because they were blocking the property, Lord, by putting up some temporary obstructions. They were constructing some temporary gates. Therefore, I preferred this application, Lord, that is CAN 2.
CAN
With a copy
2 of CAN 2 of 2026 in your writ petition, as well as there is a CAN 2 of 2026 in his writ petition.
But I stand corrected, Lord.
Yes. देखो CAN 2 of 2026 in item number 58.
CAN 2 to.
Do you have any objection to that prayer?
No, I don't. I don't have.
আসুন। Can 2 of 2026 in WPA 231828 of 2014. This is an application seeking for recording the death of petition number 1 and expunging her name. Mr. Suresh Chandra Manna, learned advocate for the applicant, submits that the petition number 1 Josna Bhattacharjee expired on 5th July 2024, leaving her only legal year, petition number 2, নামটা হচ্ছে Debashish Bhattacharjee, leaving petition number 2 Debashish Bhattacharjee as her only legal year. He seeks for expunging the name of petition number 1 from the array of petitioners. Mr. Indrajit Bhattacharjee, learned advocate appearing for the opposite parties, does not raise any objection to such prayer. It is found from the death certificate that petition number 1 Josna Bhattacharjee has expired on 5th July 2024. It is categorically contended in the application that petitioner number 2 is the only legal year. In view of the above, let the name of petition number 1 be expunged upon her demise. Can application, a department is directed to carry out the necessary amendments in the cause title of the writ petition being WPA 33182 of 2014. Can 2 of 2026 stands disposed of?
We do not have any copy. I'm appearing for the Kolkata Municipal Corporation.
Which copy?
Now the question is,
Which copy, sir?
these copies, the scan and all, what are being moved before your lordship, we have not been served with any of this application. You will serve, and you are moving it now today. I'm yet to understand this sort of practice, and you learn it.
Be excited, please.
Second thing, I'm not a party at all. Your lordship would kindly see the cross title. My junior says that corporation is not a party, but still I'm being asked to appear before your lordship.
Who asked you?
They have given.
Corporation is
They
not
have
a party.
given
The
a
main
note, they have
petition. I have filed
us,
for
and
application
I
for
do not
addition of
find.
party.
Sir, please allow me to go through the record.
Yes, your lordship goes through.
Addition of party application করেছে।
আরে কোথায়
এটা কি
লিখেছো
এটা
না?
মূল পিটিশন।
হ্যাঁ
এটা মূল পিটিশন
এবারে
পার্টি না থাকে অ্যাডিশন অফ পার্টি করবে।
এটা addition?
ওটা দেখি না একটু।
এটা addition?
কোনটা অ্যাডিশন অ্যাডিশন পার্টি অ্যাপ্লিকেশন সাব করেছি আমি।
আরে addition of party ফার্টি কোথায়? একটু আমি আপনাকে
এই তো
দিচ্ছি,
এটা।
এই কাগজ আছে।
আমি কি
হাজার
করে
কাগজ
করবো?
নেই।
আগে যে ছিল আমি কি করে করবো? আমি আর একটা কপি দিতে পারি।
To give it.
আচ্ছা দিতে দেবো আপনার এটা দিন।
ওকে নিন।
চৌদ্দ নম্বর পিটিশন এটা মেন 14 তো 2014 এটা দিতে 2014 কপি আমি একটু আরেকটা দিয়ে দিচ্ছি।
লিখেছি তবে আসছে না কেন রেসপন্ডেন্ট?
একটা ফোন নাম্বার দিন দিয়ে দিচ্ছি।
रेस्पोंडेंट नंबर लिखो
But in all the other orders, previous orders, I find that you have appeared on behalf of the KMC.
Because I have been served with a copy of the writ petition, but your lordship would kindly peruse the cause title and the prayers. There has to be some substantive prayer against the Kolkata Municipal Corporation, and there has to be some pleading that yes, corporation has failed to do this or he has done it. So either way, I am brought into the proceeding.
Which writ petition copy has been given to you?
My lord, I have been given 3356.
This is by Mr. Bhattacharya.
And 33182 of 2014. I have been provided with two writ petition. One is 33182 of 2014. Second one is 3356 of 2023. My lord, from the pleadings, from the cause title, and from the prayers, I do not.
Petition. I have filed an application for additional party. এগুলো তো additional party আলাদা ফাইল করেছি।
আপনি এইভাবে বলবেন না, আমাকে বলতে দেবেন। Now, in the prayer, in the pleading, and in the cause title, I do not find anything, any iota of.
Mr. Bhattacharya, is there any application for addition of KMC in your writ petition?
Yes. Yes. No, not in my writ petition. It is an application preferred by them in their writ petition.
Oh.
And the allegation is that not that
What is
we
the
have
number?
made an unauthorized.
Number can number one. Number one.
What is the number of the can
Number
for addition of?
One of
Your lordship allows me for 2 minutes. The dispute is Refugee Rehabilitation Corporation allotted a land. And now dispute is in respect of this land between the private respondent and the petitioner. Now, in that writ petition, somebody who is in possession is making a construction. That gives rise to an absolutely separate cause of action, unrelated to the matter which is before your lordship.
Addition of party application has been served upon you.
My lord, I am yet to receive.
নতুন এসেছেন আপনি এর আগে তো যে ছিল তাকে
হ্যাঁ 33 বছর হয়ে গেছে আমি নতুন এসেছি
না এই কেসে আপনি নতুন এসেছেন এর আগে তো দিয়েছি
Do you have any objection to the application which has just been allowed for expunging the name
of
Josna Bhattacharya?
I have no relation with Josna Bhattacharya.
Okay.
I do not know who is Josna Bhattacharya. I'm yet to understand why I am being implicated in these proceedings.
That will decide in the addition of application. That addition of parties application be served upon you. Learned advocate for the applicant of CAN 2 of 2026 in WPA 33182 of 2014 is directed to serve copy of the CAN application upon learned advocate representing the KMC. And the addition, what is the CAN number? As well as application being CAN
1.
CAN 1 of 20?
20.
Mr. Bhattacharya, what is the CAN application number in his writ petition for
But I have been served with a copy of the application, but the number is not mentioned in the application, the copy which has been served upon me.
What one?
8402 of 2016. List this matter under the heading application. give can 2 of 2026 and 8402 of 2016 to the learned advocate for KMC. Serve it.
Grateful.
Huh? Specially assigned under application. এই অ্যাপ্লিকেশনস গুলো না শোনানি হলে হবে না, এমনি রেখেও দিতে যাওয়া যেতে পারে, এমনি যদি লিস্টে থাকে অ্যাপ্লিকেশন নাও যেতে পারে তো।
Grateful.
Weeks.
My lord, only my humble prayer, my lord. Item number 58, at first let it be half. It will be half.
Why?
Item number 58.
Both will be heard together. It is appearing together. Both will be heard together.
My lord, 58.
Without serving the copy, why are you moving the application? After
58 is the
dictating
first
the order,
petition,
somebody comes and says that copy has not been served. This becomes an embarrassment.
My lord, 58 is the.
Why don't you serve the copy prior to moving the application? Serve both the applications to the learned advocate for KMC. After 2 weeks, this will appear. Now,
My lord, before that, lordship, in item number 59, my lord, assigned matters, my lord, I have been directed by your lordship to file a report, my lord, in the form of the affidavit. If your lordship give me the permission, my lord, then I will file this report, my lord, in item number 59.
not next week I'll take it up.
As your lordship.
72. Is for opposite party number 1.
Opposite party number 1 is the state, my lord. Opposite party number 2 is the husband.
No, 1 would be the private party.
Private party is the husband, my lord.
Who is it appearing for husband? What is your instruction with regard to the direction that was issued by Honorable Supreme Court to pay 10,000 per month?
My lord, the last of the instruction that I have received that it was paid in January 2025.
January. And regularly after January, this has not been paid.
That almost, my lord, 1.5 years. Almost January 2025, and we are in today in July 2020. It's the end of July 2026. 7 months over there, 1 month, 1 year over there.
By the determined date, you pay all the dues.
10,000 per month in 4 months. So he was under the wrong pretext. It's for 4 months. 1 year within 4 weeks, he paid that.
Learned Supreme Court's order
For 1 month.
would
So he
appear
was-
at page 37 of my supplementary evidence.
That was his fault. He could not. He will pay this person.
Kindly takes the pain to
Wait. By the returnable date, after 15 days, you first clear the dues that has accrued all these days from February 2015, 2025 till July 2026.
Lord, may I just place the order of the Honorable Supreme Court? My lord, this was directed that we request the High Court, my lord, page 2, to consider expediting the hearing of the case as it is pending since 2012, preferably within a period of 4 months from today. By way of interim arrangement, the appellant shall pay a sum of rupees 10,000 per month to the respondent in the first week of every month. The appellant shall also pay 1 lakh. So, my lord, he was under the impression that this need
4
to be
weeks,
paid
4 months.
4 months, and he had paid for 4 months: October, November, December, January. So, my lord, may I beseech your lordship, my lord, if the main application can be heard out and decided, so whatever is to be decided, the magistrate will, because, my lord, the order of the Honorable High Court also, which has been set aside, although set aside, that also has granted the onerous duty on the magistrate to decide the quantum. Supreme Court, by way of interim arrangement, had fixed this up. Nothing more, nothing less. This is my only submission, my lord. Well, if this can be heard out, whatever the dues, if any at all, and all can be decided by the magistrate upon.
So this is against the interim order.
No, my lord, the application itself was dismissed.
Order of dismissal they have made.
Dismissal of two courts, the magistrate, the sessions court. Now, against that, a revisional application was preferred here. On the limited question, as your lordship is very well aware, I need not say all this, that on the limited, within the limited sphere of whether that order of the appellate order was sustainable or not. Now, since the husband was not represented, the order of the Honorable High Court of the Honorable Coordinate Single Judge was again challenged in the Supreme Court. Supreme Court set aside that order and remanded back to your lordship for deciding. That's CRR. This is where we stand. And may for the benefit of all, may I place the orders? It will probably ease out things.
Before that,
তোমার মামলা করো না, তুমি শুরু করো না।
my daughter senior friend says that the husband was of the opinion that he has to pay for only for 4 months. The order was passed on October 4 to 2024.
Right.
So that would come to January 2024.
Five.
January 2025.
তাই দিয়েও
After, my lord, the matter is pending and we have been renewing our prayer for payments. Just for the pendency or the paucity of time, the matter is not being taken up or anything, my lord. My lord, can the payments be stopped? I was only requesting on the others. My lord,
my lord, I do not understand.
Some payment could be
I am willing to get the matter heard out today
No,
itself.
we are not standing on the, I was
Then
only praying that whether the
come out
payments
with
or
the matter. Let us decide the matter, finish
No,
it, and let us go to
deciding the matter.
the trial court.
If my lord even decides against us, let's take an assumption.
Oh.
My lord, the matter decides. This is 10,000 per month.
That is not a final order.
Does
Sir?
give it a month, my lord, gives it a right that that money will not be paid just due to the pendency of the matter.
Sir,
And
that-
is the matter I'm placing it. But my lord, I'll ask my senior friend to make arrangements that some money could be paid to the wife.
Let us decide the matter today itself. If it is dismissed, you get nothing.
Those order was, but it is not never written only for 4 months. It was requested to dispose of the matter for the 4 months.
Again, you want to go to the Supreme Court. Chol.
That was my lord's view also. My lord's view also on the last date was also it.
hearing
that some payment may be made. No, whenever there is payment has to be made. Now, other options are to be opened.
Yes.
Lord, kindly first come to the order passed by the Honorable High Court. My lord, it would appear at page 25 of my supplementary affidavit. Filed by the petition.
Okay.
4th September.
4th September, my lord. 4th September. 4th September. Now, Mr. Edwin, learned advocate appearing for the OP number otherwise prayed for recalling. This is the recalling of the order. My lord, earlier which was passed, my lord, I stand corrected. My lord, kindly come terms takes the pen to turn to page 17. My lord, only the same affidavit, my lord, page 7.
Yes.
My lord, the second paragraph, the starting with I have considered. I have considered the judgment which was delivered by the learned magistrate on 28th of September 2011 and the yardstick which has been fixed for proving a case under section 125 of the Code of Criminal Procedure. Learned court at one breath has reported that the husband used to assault the wife frequently and drove her out of the matrimonial home. At the same breath, the court expected complaints and medical certificates for assessing whether there was any neglect or refusal to maintain the wife. It is surprising that the learned court ignored the case under section 498 of the Indian Penal Code, so filed by the instance of the wife, and on misappreciation of the evidence, came to the conclusion that the wife failed to prove the factum of neglect or refusal. The learned session court, while exercising its revisional jurisdiction, ignored the observations, reasons assigned by the learned magistrate for arriving at a finding so far as refusal of maintenance in the instant proceedings are concerned. I am of the view that the judgment dated 28th of September 2011, passed by the learned judicial magistrate, 5th Court, Hooghly, and affirmed by the learned district judge Hooghly by his judgment and order dated 12th September 2012 in criminal motion number 254 of 2011, suffers from perversity and as such requires interference of this court. Needless to state that only drafting in the judgment regarding the object of the legislature for incorporation of the provisions of section 125 of the Code of Criminal Procedure is not enough. But what is expected from the courts are to give a flesh and blood and life to the provisions. The order so passed by the learned magistrate on 28th of September 2011 and the learned sessions court on 12th of September 2012 as such is set aside. Learned magistrate is directed to issue notice upon the parties, counter the and consider the quantum of measure to be granted to the present petitioner wife. The learned magistrate will also it goes to say, my lord, the next is my lord kindly comes to the next paragraph, next page, my lord, 3 lines from the top. My lord, if the learned magistrate comes to a conclusion regarding the quantum to be allowed to the wife, in that case, the learned magistrate would also assign reasons while fixing the date from which the maintenance should be granted. This is what happens, my lord, when we approach this honorable court in this present scene. Thereafter, my lord, they file a application for recalling. The order would appear at page 25. My lord is, my lord, I am able to indicate page 25. Second paragraph, learned advocate submits that the order was passed behind the back, particularly in case where the OP number was successful before the learned magistrate or institution, but the learned session court 2 was only this court which interfered with the order. Both the courts below are set aside the same. My lord, the third paragraph at page 26, but the present case relates to survival of a lady, and as such, this court was empowered under section 403 of the CPC to pass an order in a revisional application without hearing any of the parties. I have considered the submission of Mr. Edulji, learned advocate of the OP number 1, the nature of application which has been taken out due to operate a bar under section 362 CRPC. Accordingly, no interference made with the earlier order such and such with the aforesaid application. CRAN is dismissed. Thereafter, my lord, the husband approaches the Honorable Supreme Court, and they would appear at page 37. Yes. My lord, heard the learned advocate counsel for the parties. We are inclined to entertain this appeal only on the ground that the appellant has not been heard in the revision petition before the High Court. We have also produced the order passed in the review application where the aforesaid factum was taken note, but nonetheless, the said application was rejected. Inasmuch as the appellant has not been heard and there is no indication of his representation before the High Court, we are inclined to set aside the impugned judgment. Accordingly, the impugned order is set aside. The matter is remitted to the High Court for reconsidering CRR on merits and in accordance with law after affording an opportunity to the parties. We request next page, page 38, my lord. We request the High Court to consider expediting the hearing of the case as it is pending since 2012, preferably within a period for 4 months from today. By way of an interim management, the appellant shall pay a sum of ₹10,000 per month to the respondent in the first week of every month. The appellant shall also pay a sum of ₹1 lakh to the respondent within a period of 4 weeks from today. Accordingly, the appeal stands allowed. This is the current scenario. Now, my lord, what grounds the Honorable High Court had interfered the orders and my lord has passed, may I indicate those things? But kindly takes the pain to come to page 53 of my supplementary evidence. Am I able to indicate page 53, my lord, of the supplementary?
of the,
supplementary affidavit.
yes.
The income, the affidavit of income and assets, my lord, of the husband. Kindly looks into it. It is the name Anitab Singh. Kindly comes to column number, my lord, 10. Monthly income as mentioned as serial number 45. Nil. But monthly expenditure as mentioned as serial number 60, 9,900. Kindly turns to the next page, 54.
This is serial number 60 of
Of this, my lord, affidavit and assets.
the document number 60.
Yes, my lord. Now, the serial number 45. See, serial number 45 would appear at page number 62, my lord. Total income nil.
Yes.
My lord, serial number 10, monthly income as mentioned as serial number 45 nil. My lord, returns to page 62, my lord. Total income nil. And again, my lord, serial number 11, monthly expenditure 9,900. Now kindly looks to the same thing. Kindly looks to page 66.
Yes, 60.
60 total expenditure 9,900. The income is nil, but there is enough expense. 10,000 in 2022 is enough, is more than enough for a single person, according to them, according to him. Now, kindly comes to page 54. My lord, am I able to indicate page 54, my lord? Now, whether you are assessed to income tax? No. Whether you have sufficient income to support yourself? No. Thereafter, my lord, serial number 15, whether you are staying at matrimonial home? No. My lord, 12 and 13, kindly marks, my lord, 12 and 13 in our case. Thereafter, my lord, kindly comes to page 57.
Column number.
Yes, but this is related to children. There is no children, so nil. All goes nil. Kindly comes to page 59. My lord, 59, column number 41. In case of self-employed persons, whether the business profession is carried as an individual, sole proprietorship concern, nil. Partnership concern, company or association, on the next page, HUF, joint family business, all goes to say nil. Number of employees, nil. Annual turnover, nil. My lord, 42, in case of business profession is carried as a partnership firm company, nil. The whole column goes on. Say 61, all goes to nil. Page number 43, income from other sources. Sorry, column number 43, page 62. Nil. Thereafter, then others are his expenditures. Page 65. Column number 55, legal litigation expenses, 3,000, person going to Supreme Court. Thereafter, my lord, 56, credit cards, haircuts, debit, purchase, nil. Real estate, column number 61, nil. Joint property is nil. It goes on to say, my lord, he has no income of his own. He is not even employed with anybody. He is only getting money from God's grace. And my lord, he is going on with his life. Now kindly turns to my lord, page 81E. Yeah. This is his bank statement, my lord. My lord, income sources nil, but money is entering into his. But kindly comes, my lord, this is very, my lord's copy is legible. My lord's copy is quite legible. I have a very. So this is the petitioner's bank account where 1 lakh has been paid. The 6th, where the credit amount shows 1 lakh.
11 November.
According to the Supreme Court's order, everything goes nil. Supreme Court's order, they pay 1 lakh. My lord, it comes from the 6th one, my lord. With the credit column, it shows 1 lakh. It is coming from Bank of Baroda. Yes. It is the bank account of the husband. I'm on page 80. My lord, am I able to indicate page 82? My lord, this is of 2006. He has no source of income, my lord, he has stated.
Page 82 of?
82, my lord, it is supplementary affidavit. It is all in going through a supplementary. 82.
There is. 82 is an agreement.
My lord.
Yes, agreement.
My lord, he has stated that he has no source of income, not employed in anything, has no source of business. My lord, this is an agreement made on 2006 between the Santosh Kumar Singh. My lord, kindly takes 1, 2, 3, 4, 5, 6, 7, 8. My lord, 8, the 9th line. Its proprietor Sri Anitabh Singh, son of Sri Vishwanath Singh. Lord, he is a developer promoter owning, my lord, Messrs. Nath Constructions. I'm sorry, my lord.
Yes.
Kindly looks into the kindly bear a moment with me. Consideration of Buddha. No, me. My lord, he says he doesn't have an copy. My lord, kindly to takes up to my page number 89 once. The same good document.
Yes.
My lord, the third column under schedule 3, the second column under schedule, third under the page, part 2, manner mode of payment, as advance 51,000, 4,59,000 remaining balance.
59 years.
Kamala kindly turns to page 92 once. My lord, this is the present wife, the present child. My lord, the right hand side is the present wife. This is the present side. This is the vehicle that the OP number 2 drives or used to drive. But these are Facebook posts taken from these wives, the present wives.
My lord, these will probably cannot show. These he cannot show.
My lord, 93, 94, 95 is the petitioner with the present family. Sorry, my lord, the OP husband with the present family. But it goes on and whatever my lord, data we could collect. My lord, page 97. No vehicle, nothing. We could get a vehicle in his own name. Now, my lord, today, my lord, considering the litigations that is going on, my lord, this makes the husband more cautious of not having a property or assets or of any nature in his own name, or business also his own name, my lord. But he is maintaining the same lifestyle that he used to maintain as on the date of when he has deserted his wife. He has married, he has a family. Our dispute is not with the same. Our only dispute remains that he has to maintain his wife. He is maintaining all his assets, all his properties, everything, not in his own name, but in his present wife's name. He's running a business, my lord. He used to run them from the date of divorce or when from the dispute arose, my lord, changing a proprietor or changing a, my lord,
Divorce was a
director.
contested divorce, or it was a mutual consent divorce?
No, I think, my lord, divorce was granted, then, my lord, it was ex parte, then it was challenged, it was again, and now it is again contested. My lord, the income and assets, if taken, material clearly show a disproportionately wrong with the lifestyle that he is maintaining.
Okay, that's it.
That's all. My lord, I have a sir, dues. My learned friend want to show the dues. That is the first submission.
Actually, my lord, probably all that I have learned in my student years as a student of law and thereafter as a lawyer, my lord, we are in the revisional court. After the appellate order has been passed, none of the issues raised on facts can be decided by your lordship today. All that he has said is pertinent to what has happened already and decided by two of the courts. But before I go into that, whether that is can be decided by your lordship or not, let me place a few more things. Well, why are we here today first? We are here today because the Honorable Apex Court has set aside the order of the coordinate bench. So, my lord, may I read the order? Again, for better understanding of my learned friend also and myself. Accordingly, the impugned order,
this order of
the Honorable Apex Court.
Yes.
He started his submissions with the order of the Honorable High Court. Although, in my humble estimation, it should have started from the magistrate. Why we are here, we need to understand. Accordingly, the impugned order is set aside and the matter is remitted to the High Court for reconsideration, reconsidering the CRR number ato on merits and in accordance with law after affording an opportunity to the party. So, the order of Justice Ghosh today does not survive at all. Neither I can rely on it, nor he can rely on it. It's been set aside. So what stands today, my lord? The order of the learned magistrate, the order of the learned session judge. Now let us come to those orders. Because those orders categorically refused his maintenance. That is why he had come up. Now, Why was the maintenance refused? ভাই এটা আমার পক্ষে পড়া খুব ডিফিকাল্ট, তুমি পড়ো দেখি একটু ভালো একটা ম্যাজিস্ট্রেট অর্ডারটা ভীষণ ইললিজিবল। P12 64 my lord comes
The copy of the evidence.
অসম্ভব একটা, হ্যাঁ দেখি পড়ে দিই।
Sir, you have annexed the copy of the evidence also. Evidence copy has been annexed.
Evidence needs to be seen because both the learned courts decided on evidence. না না নেই 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 মাই লর্ড জিজ্ঞেস করছেন অ্যানেক্স করেছো কিনা, না অ্যানেক্স করা নেই, আমি দেখেছি নেই।
Only one affidavit in evidence which was submitted before the trial court. That is there at page 22.
আমার এখানে
22 of the revisional application.
আমারটা যাই
For the cross examination, all that is not there.
ক্রস হয়েছে, সেশন কোর্টের অর্ডারে আছে, এটা সেশন কোর্ট এভিডেন্সটা রেফার করেছে, এই দেখো।
This is the chief.
That is
এটা
the
একটা
chief.
ক্রস আছে, এই যে
LCR
সেশন
was
কোর্টে লেখাই আছে she has admitted at the time of cross examination, মানে ক্রস আছে, ক্রস হয়েছে, সেটা অ্যানেক্স নেই, আমি পড়েছি এটা।
দেখুন এটা LCR টা কি কল করা হয়েছিল?
LCR
LCR
টা
was called for? LCR টা কল করা হয়েছিল?
পেলে ওই জাজমেন্টটা পড়া যাবে ম্যাজিস্ট্রেটের, একটু বেটার, আমাদের চেয়ে মার্জিনালি বেটার।
Who can place? You have got the copy of the evidence.
এভিডেন্সের কপিটা আছে, ক্রসটা নয়, ক্রসটা TCR is here my lord, TCR.
That I'm finding out whether this was called for or not. If you have the certified copy from
No,
your side,
that
you can
is-
place it.
না
এইটা যখন শুনানি হয়েছে তখন এলসিআর কল
না 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 কি হয়েছে ঠিকই বলে, when it was first heard it was disposed of at the very first instance, so there was no scope of calling for the TCR. Matter went to Supreme Court remanded it back, so TCR was never called for.
Okay, either of you can place that. If you have the certified copy, you get that certified copy.
We can say my lord,
State cannot call it. It is a dispute between the private parties.
এটা হ্যাঁ আছে, এই যে চিফ ক্রস, হ্যাঁ
It is there.
হ্যাঁ
Okay.
ঠিক আছে, আমরা এটা
Yes.
পেজ, এটা হচ্ছে পেজ 54
54 of the
revisional application.
54. Yes.
এক মিনিট আমি নিজে দেখি।
EW1. How many witnesses were there?
This is the only evidence, my lord.
Oh, one on behalf of the petitioner, other on behalf of the opposite party.
One each.
Oh.
Now,
Yes.
I will come to this, my lord. But before that, may I read out the ওই ম্যাজিস্ট্রেটস, এটা দাও না বাবা, তোমার পিটিশনটা পড়া যাচ্ছে, আমারটা পড়াই যাচ্ছে না। My lord has got it. This is page 64.
Yes.
The instant petition under section 125 of the Code of CRPC has been filed by the petitioner such and such, claiming maintenance from such and such. The petitioner's case, in a nutshell, is that the petitioner is the legally married wife of the OP. Their marriage, my lord has got it. The marriage was solemnized according to Hindu rites and customs. After marriage, she started conjugal life with the OP at his house at 17 such and such, such and such. Before the marriage, rupees 3 lakh dowry was given in accordance to the demand of the OP. Again, after marriage, father of the P had to give such and such, such and such. This goes on. Now, my lord, next page, again, my lord, this same things. Now, the claim here at page 2, your lordship will find somewhere middle left side, the petitioner has no income of her own and is fully dependent on her father. The OP, on the other hand, has business of promoting, which is their family business. The family of the OP earns rupees 60,000 from rent of their house. They have a petrol pump at Durgapur, and from that petrol pump, their family income is 50 lakhs per annum. They have lending business, and from there they earn such and such. Out of all this, OP gets a share of rupees 10,000 per month, in spite of having sufficient means such and such. Therefore, she pays for 15. So, my lord, this was specifically her case, that the income is family income, not the person's personal income. That is why the list of assets shows such and such. The expenditure, 9,900 something. Oshottama hiti hoto iti gojo. He did not read the next column, which says the person with whom the petitioner was staying was his father and mother. They are the owners of the business. Right. So his income, as per their own case, is the man got 10,000. Now, the OP appeared page 3. The OP appeared in the case and filed written objection and contested the case. Now, all the contents of the petitioner has been denied by the OP in the written objection filed by him. Only the marriage is admitted. The case of the OP is that no dowry was given at the time of marriage, only some articles like clothes, utensils, etc. We are not concerned with this. Now, somewhere a little below, my lord, your lordship will find the OP. Now, my lord, I am not reading it aloud. This is, your lordship will see. না পাতার ওই পোর্শনটাই পড়া যাবে না।
Yes.
My lord has read it. Now, the reasons who left whom, it goes on. I am, for the sake of civility, I am not reading it aloud. Now, the suit at the bottom of the page, what happened to the suit? Once the suit was decreed, she comes up with the 498A. That's the next page, page 4. Now, decision with reasons. I have gone through the evidence laid down by the petitioner and her witness. The petitioner has filed affidavit in chief, which fully corroborates the case of the petitioner. The petitioner has stated that after marriage, she started conjugal life with the OP. The OP used to assault the petitioner frequently. Ultimately, the petitioner was driven out of her matrimonial. Since then, she is staying at her father's house. The OP does not provide any maintenance to her. The OP has married again for the second time. The petitioner has no income of her own and is at the verge of starvation. The OP, on the other hand, comes from a rich family and has varied family business, which includes promoting, money lending, etc., petrol pump. And the OP earns about rupees 10,000 per month, and in spite of having sufficient means, neglects to maintain the petitioner. Therefore, the petitioner prays for maintenance of 15,000 for herself. PW2 is the relative uncle of the OP. He has stated that he knows the petitioner as she is the wife of the son of his younger brother. Except this, he did not say anything in support of the case. And the petitioner, no other independent witness was cited from the side of the petitioner. The OP examined himself as OP W number 1. All the allegations have been categorically denied. In the affidavit in chief filed by him, his case is that the petitioner has voluntarily left him. For that reason, she is not entitled to claim maintenance. Moreover, he has obtained divorce from the petitioner, now has married again and is living with his present wife. At the time of cross-examination of the petitioner, 2 documents were shown to her from the side of the OP, which have been marked such as such. In order to decide as to whether the petitioner is entitled to get the maintenance, the first thing that needs to be decided is whether the OP has, without reasonable cause, neglected to maintain the petitioner. Section 125 CRPC is a beneficial piece of legislation, which was specially, these are, right. The paragraph, the petitioner has stated volumes about the income of the OP, but she has failed to give even a single document in support of the income of the OP or even his family members. Also, not a single witness has corroborated the case of the petitioner in this respect. Thus, the petitioner has failed to prove the income of the OP. The petitioner has stated that she was tortured and severely assaulted by the OP on many occasions. During cross-examination, she admitted that she did not lodge any complaint at any place regarding that assault. She has not consulted any doctor after being severely assaulted, as is alleged. No witness deposed in favor of the petitioner in order to substantiate this claim of the petitioner. Now it is quite astonishing that the petitioner did not feel the need to get any medical treatment after being severely assaulted, as is alleged. Moreover, she did not make any complaint at any place is also astonishing. Even it be so noted that the petitioner under any compulsion could not lodge any complaint at any place, then also any of her relatives, especially her father, could have lodged such complaint. So considering all these aspects, it would be safe to presume that the petitioner has failed to prove that she was tortured in the hands of the OP or his family members. Now, the question remains is whether the petitioner was deserted by the OP, whether she was driven out of the house of the OP. In this respect, it would be pertinent to draw attention towards the facts elucidated at the time of cross-examination of the petitioner. She also admitted at the time of cross-examination that as she did not keep any relation with her husband for 6 long years, so the OP filed the divorce suit against her. If this be the case, then as it can be presumed that the petitioner has failed to prove refusal or neglect on part of the OP. Now, considering the vivid discussions made above and also considering the fact that the petitioner has failed to bring enough corroborative evidence to support her claim, it appears to me that the instant petition cannot be allowed, hence rejected on contest. Right. Now, this order was challenged before the Sessions Court. The order of the Sessions Court, impugned order. আমার কাছে এটা আছে। My lord, the impugned order. Order dated 12/9/12. My lord has impugned order, my lord has got.
What is the MC number of this?
হ্যাঁ এই যে সেটা হচ্ছে 254 of 2011.
250.
না না impugned order তো ওখানেই থাকবে। Should be at the end of
254/11, yes, dismissed on contest.
এটা না 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 আমার এইটা না হ্যাঁ থ্যাংক ইউ
254/11, yes.
না না এইটা এই তো এইটাই
It is 12 September order.
12/9 September.
Yes.
12 September 12. হ্যাঁ petitioner is the wife. No steps taken on behalf of the petitioner. The respondent opposite party is present by filing Hazira, and so the said respondent number 2 is present. The case is taken up for consideration on merit. Heard the learned advocate, etc. This is an application under 397, 399 of the CRPC against the impugned judgment dated such and such, such and such. The petitioner's case is that the petitioner is, the case is again repeated. Now, page 2, the application was contested by the OP by filing written objection. And the learned judge now says, the application was dismissed by the magistrate, and thereafter he begins. Being aggrieved and dissatisfied with the order dated 29/9/11, the petitioner prefers this criminal motion on the ground that the impugned order passed by the learned magistrate is bad in law and has failed to consider the fact that the petitioner has no independent source of income of her own, and that the OP has sufficient income from different sources, and that the learned court below ought not to have been swayed by emotion, denying the hard reality, and that the learned court ought to consider the neglect and refusal made by OP to the petitioner, and that the learned court, etc., etc. Decision with reasons. I have heard the learned advocate for the, my lord, I have heard the learned advocate for the petitioner and perused the impugned judgment. It has been contended in the petition itself that the OP number 1 has sufficient income having a petrol pump at Durgapur, whereas the petitioner has no income of her own, and that she requires 15,000 per month for herself to maintain lifestyle. On the contrary, OP number 1 has contested the suit, denying all the allegations made by the petitioner. It revealed from the judgment impugned that the petitioner contact, my lord will kindly read it.
Yes. Yes, this is the same one.
Now, next page. I have gone through the order of maintenance as awarded by the learned court and below, and decided whether the petitioner is entitled to get maintenance. Now, the first thing that needs to be decided is whether the OP has, without reasonable cause, neglected to maintain the petitioner. Section 1. My lord, this also the same beneficial piece of legislation at the bottom of the page. The petitioner has stated volumes about the income of the OP, but she has failed to say, my lord. Be it mentioned here that the learned court below has rejected the application on the score that as to whether the petitioner was driven out of the house of the OP. In this respect, it would be pertinent to draw attention towards the facts elucidated at the time of cross-examination. She has admitted at the time of cross-examination that she did not keep any relation. Same thing, etc., is repeated. So, my lord,
yes,
the motion is dismissed on contest. Now, my lord, the first and the foremost requirement of section 125 is that a lady should be in a vagrant state where she cannot maintain herself. Why? Because the other person who is liable socially or under any law is neglecting to maintain her. This is the entire conspectus of the concept of 125. One of the first criterion that I have not maintained my wife has fallen flat in both the courts. Before, when the examination took place on the evidence and in the appellate court, the lady admitted herself that she was the person who had left the petition, the husband. Now, this is where I draw your lordship's attention to the evidence now. Although, my lord, I am fully aware that your lordship is not in a position to appreciate the evidence, because this being a revisional jurisdiction, we are to only confine our my lord submissions to the two judgments, nothing more, nothing less. And unless a gross abuse of the process of court, a gross illegality, patent erroneous facts can be brought to your notice, revisional court is not widened. The powers of your lordship are not widened. But still, to satisfy my own conscience, my own, my lord, morals as a lawyer, my lord, I request your lordship to kindly look into the evidence also. My lord, page 57. Page 57. Para 17, Bangladesh Hatero. Last line. হ্যাঁ 17 তো রে ভাই, পেজ 57 এর 17।
Yes.
Now, my lord sees 17 para 17 last line corroborated. This is the piece of evidence which decides actually whether I have driven out that woman, I have failed to maintain her. This is the piece of evidence clearly. Now next page your lordship turns over. Middle of the page, আমি সেদিন কোথাও কোনো অভিযোগ করিনি, তারপরেও কোথাও কোনো অভিযোগ করিনি এক্সেট্রা। এফআইআর করলাম কারণ ওরা পঞ্চায়েতে ফয়সলা হচ্ছিল। The reason for filing that FIR also.
Yes.
ঠিক আছে। CRPC data. তোর কাছে এটা CRPC নেই? মানে আইপ্যাড ফাইপ্যাডে কোথাও একটা খুলে দে, 125টা খুলে দে।
পুরোনোটা লাগবে না?
পেয়েছি। Now, my lord comes to 125 subsection 4. There is a bar under law. I'm reading it for the benefit of my learned friend. No wife shall be entitled to receive an allowance for the maintenance or interim maintenance and expenses of proceeding, as the case may be, from her husband under this section if she is living in adultery, forget it, my lord, we are not, or if without any sufficient reason she refuses to live with her husband, or if they are living separately by mutual consent. My lord, I believe the second clause, she without any sufficient reason she refuses to live with her husband. This is what she has deposed in court. After this, my lord, the law says she is not entitled to maintenance.
But if one leaves the matrimonial house out of compulsion,
that is also, it was, my lord, that question was also put. For 6 years, she did not say a word to anybody. 6 years, she did not say that she had been assaulted, she had been driven away. It was only after the husband got the order of divorce, she filed the 498A and came up with this allegation. That is also admitted. That is why I had shown to your lordship the next page. My lord, page 58. গেল রে ভাই 58 যেটা দেখাচ্ছিলাম। স্বামীর ডিভোর্স হয়ে গেছে জানার পর এবং সুইসাইডের দরখাস্ত করা ইত্যাদি, ওই সময় ডিভোর্স হওয়ার বাদই আমি 498 এ ফাইল করেছিলাম। পেজ 57 লাস্ট।
yes.
So, my lord, subject to correction, I am squarely covered by clause 4, number 1. She admits that she is the person who left the house. Third, she admits with regard to the income what my learned friend has placed. Now, what I was saying, Ashwattama Hato iti Gajo, what he did not show in the assets list, my lord will come to now. The list of assets submitted, clause 16, page 54. It supports their case so far as the income is of the family, not of the man. Page 54. Clause 16. I'm living with my father and mother. And she also says it is the parents who are the owners of the business, etc. He gets a mere sum of 10,000.
But what about annexure P23?
My lord, annexure P20, this is the family business, and here your lordship sees P23.
Yes.
Yes. My lord, this is the Nath construction. This is a family business.
But he says that through its proprietor, Sri Amitabh Singh.
Amitabh Singh as developer.
This Nath construction is a proprietorship business. You cannot claim it to be a family.
My lord, that is what has been stated by her. And this, the only thing that I need to see. And this was now the Nath construction. My lord executes this for development, and the amount for execution is 51,000. 51,000.
4,59,000 is due.
Due.
5,10,000 is the total amount of the value.
But 4,59,000 has not been. Now, so far as the rest of the annexures, they are not admissible before a court because these are photocopies of certain
How
pictures.
do you interpret that the affidavit which has been filed did not, the Nath construction did not find place in the affidavit?
My lord, the only thing is, my lord, so far as Nath construction and this, I have no personal instruction. My lord, today it is 4:30. Tomorrow your lordship keeps it. I will come up with
coming week, because Wednesday I'm taking up the revisional matter. So coming week.
And I will just cite I'll cite a few judgments in this regard.
My lord, I will require a 5 minutes reply and authorities.
Finish it off in the next week.
Next week is my lord, same position. কি বলছো?
আমার কোনো অসুবিধা নেই।
উপর দিকে না শেষ
যা বলবে সবেতে হ্যাঁ আমার নাম
আর Mr. Spencer, learned advocate appearing for the petitioner who concludes his argument.
আমি তোমার জন্য বইটা পাঠাবো।
Argument is also advanced on behalf of opposite party number 1 by Mr. So and so, learned senior advocate appearing. ঠিক করে নেব। Is this matter on কত তারিখ? 5th August, ওপরের দিকে রাখবে টপে।
May I have your lordship's leave with a very innocuous prayer? I will not
What is
disturb
the
your lordship
innocuous
at the time of rising. My learned friend who is coming from Delhi, item number 73 into your lordship's today's list, 74, which is supposed to next week is 5th. He is not available. He would be in Punjab Haryana High Court for a matter and in PMLA matters. If it can be taken on 12th. We are for the petitioner. The opposite party has never appeared. It's a 2011 CRR application.
But any administrative notice was issued to the opposite party?
Yes. They have never appeared.
Notice through police, they never. It is 74 to mark karo, it is 74 to 12th.
On 12th, your lordship.
12th.
I'm grateful. Deeply obliged. Let it retain its position. Deeply.
Yes.